Let us pray. Almighty God, we willingly acknowledge you as the Supreme Being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Oath or affirmation, announcements by the President.
Honorable Senators, I have granted leave of absence to Senator the Honorable Dominic Smith, Senator the Honorable Anil Roberts, Senator Kenya Charles, and Senator Anthony Vieira S.C., all of whom are out of the country. Honorable Senators, I have received the following correspondence from Her Excellency, the President, Christine Carla Kangaloo, ORTT. To Mr. Ashwood Jack, whereas Senator the Honorable Dominic Smith is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago. Now, therefore, I, Christine Carla Kangaloo, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Prime Minister, do hereby appoint you, Ashworth Jack, to be a member of the Senate temporarily with effect from the 26th of September 2025 and continuing during the absence from Trinidad and Tobago of Senator the Honorable Dominic Smith, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, this 26th day of September 2025. To Mr. Daniel Rashid, whereas Senator the Honorable Anil Roberts is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago. Now, therefore, I, Christine Carla Kangaloo, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the acting Prime Minister, do hereby appoint you, Daniel Rashid, to be a member of the Senate temporarily with effect from the 26th of September 2025 and continuing during the absence from Trinidad and Tobago of Senator the Honorable Anil Roberts, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the office of the President, St. Anne's, this 26th day of September 2025. To Archbishop Barbara Burke, whereas Senator Kenya Charles is incapable of performing her duties as a senator by reason of her absence from Trinidad and Tobago, now, therefore, I, Christine Carla Kangaloo, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(a) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Prime Minister, do hereby appoint you, Barbara Burke, to be a member of the Senate temporarily with effect from the 26th of September 2025 and continuing during the absence from Trinidad and Tobago of Senator Kenya Charles. To Ms. Zola Phillips, whereas Senator Anthony Vieira, SC, is incapable of performing his duties as a senator by reason of his absence from Trinidad and Tobago. Now, therefore, I, Christine Carla Kangaloo, President as aforesaid, in exercise of the power vested in me by Section 44(1)(a) and Section 44(4)(c) of the Constitution of the Republic of Trinidad and Tobago, do hereby appoint you, Zola Phillips, to be a member of the Senate temporarily with effect from the 26th of September 2025 and continuing during the absence of Senator Anthony Vieira, SC, from Trinidad and Tobago. Honorable members, senators are required to take the oath of office. Can we all stand?
I, Ashworth Jack, having been appointed a member of the Parliament, do solemnly affirm that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I'm about to enter.
I, Daniel Rashid, having been appointed a member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
I, Archbishop Barbara Gray Burke, having been appointed a member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibility to the people of Trinidad and Tobago upon which I'm about to enter.
I, Zola Phillips, having been appointed a member of Parliament, do swear by Almighty God that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter.
Honorable Senators, Standing Order 51-1J provides that, and I quote, a member present in the Senate during the debate shall, I emphasize, shall not use any electronic device in such a manner that, in the opinion of the President, disturbs the proceedings of the Senate, end of quote. In this regard, I have directed the clerk to circulate a procedural bulletin reminding senators of the rules governing the use of electronic devices in the chamber and parliamentary precincts. The chamber is a working environment. Accordingly, good sense, discretion, courtesy, and decorum should guide all members in the use of electronic devices. I wish to thank senators in advance for their cooperation. We shall be updating this bulletin from time to time.
Bills brought from the House of Representatives. The Miscellaneous Provisions FATF Compliance Bill 2025.
The Honorable Attorney General.
Mr. President, in accordance with Standing Order 62(1)B, I beg to move that the next stage of the Miscellaneous Provisions FATF Compliance Bill 2025 be taken later in the proceedings.
Honorable Senators, the question is that the next stage of the Miscellaneous Provisions FATF Compliance Bill 2025 be taken later in the proceedings. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The next stage of the Miscellaneous Provisions FATF Compliance Bill 2025 will be taken later in the proceedings.
The Counter-Proliferation Financing Bill 2025. In the name of the Minister of Finance.
The Honorable Attorney General.
Mr. President, in accordance with Standing Order 62(1)B, I beg to move that the next stage of the Counter-Proliferation Financing Bill 2025 be taken later in the proceedings.
Honorable Senators, the question is that the next stage of the Counter-Proliferation Financing Bill 2025 be taken later in the proceedings. Those in favor say aye. Those against say no. I think the ayes have it. The next stage of the Counter-Proliferation Financing Bill 2025 will be taken later in the proceedings. Okay, all right, clear.
Petitions, papers.
The Minister of Transport and Civil Aviation.
Mr. President, I have the honor to lay on the table the following paper as listed on the order paper in my name, the Motor Vehicles and Road Traffic Amendment to the 9th Schedule, Order 2025.
The Minister of Planning, Economic Affairs and Development, and the Minister in the Ministry of Finance.
Mr. President, I have the honor to lay on the table the following papers as listed on the order paper in my name and in the name of the Minister of Finance. The Financial Institutions Liquidation Regulations 2025. The report of the Auditor General of the Republic of Trinidad and Tobago on financial statements as follows. The non-receipt of financial statements of the Sandy Grande Regional Corporation for the financial year ended September 30th, 2015 to September 30th, 2024. The non-receipt of financial statements of the Digger Martin Borough Corporation for the financial years ended September 30th, 2009 to September 30th, 2024. The non-receipt of financial statements of the San Juan Laventille Regional Corporation for the financial years ended September 30th, 2018 to September 30th, 2024. And the annual reports as follows. The Chaguaramas Development Authority for fiscal years 2018 to 2019 and 2019 to 2020.
Questions on notice, questions for oral answer.
The Honorable Leader of Government Business.
Mr. President, I believe the Minister of Homeland Security is here with us today for question number 4. Question number 4, Mr. President.
All right. Okay. Mr. Government Business, you may wish to provide some guidance on question 15, as well as question for written answer.
Oh, yes.
If you can give
Of
us
course.
some guidance.
My apologies, Mr. President. We have the Minister of Homeland Security with us who intends to answer question number 4. And we have the Minister of Planning with us who intends to answer question number 15.
What about the written one?
The written questions,
Will be?
you have them. Great. The written questions, both on the order paper, have been sent to the Clerk of the Senate, I am advised, and they will be circulated to the senators as soon as possible.
Thank you. Senator Vishnu Dhanpaul.
Thank you, Mr. President. Question number 4 to the Minister of Homeland Security.
The Honorable Minister of Homeland Security.
Thank you, Mr. President. And good afternoon to this honorable House. Based on the information received from the Commissioner of Police, the Trinidad and Tobago Police Service tendered for 3,000, not 5,000, as stated in the question, body-worn cameras in accordance with the regulations established by the Office of Procurement Regulations. A letter of award was subsequently submitted in August 2024 and was issued to a contractor in the sum of $24,965,310 Trinidad and Tobago dollars. On September the 9th, 2024, the contractor provided the Trinidad and Tobago Police Service with a bond in the sum of $2,496,531 Trinidad and Tobago dollars. At present, that contract has since been terminated. Question number 2. As of June 10th, 2025, approximately 17.9% of the Trinidad and Tobago Police Service officers use body-worn cameras while on active duties. These body-worn cameras are assigned to the undermentioned division, branches, sections, units of the Trinidad and Tobago Police Service. Divisional Task Force, Interagency Task Force, Emergency Response Patrol Branch, Traffic and Highway Patrol Branch, and the 10 divisions, Port of Spain Division, Western Division, Eastern Division, Southern Division, Southwestern Division, Northeastern Division, Tobago Division, Central Division, Northern Division North, and Northern North Central Division. It is important to note, Mr. Speaker, sorry, yes, I apologize. It's important to note that the body-worn cameras assigned to these units and divisions are not assigned to personal officers. As a result, the daily use of these devices may vary on the day-to-day basis, depending on the daily assignments and rational operations across Trinidad and Tobago. Mr. President.
Thank you, Mr. President. To the Minister of Homeland Security, why was the contract terminated?
Mr. President, in a bid to save millions of dollars, the contract was in fact terminated.
Yes.
Thank you, Mr. President. Is the project still a priority for the government?
Honorable Minister of Homeland Security.
Mr. President, body-worn cameras are part of the tools for a police officer. So yes, the answer is yes.
Okay. All right. Anyone else? Let us go on to Senator Faris Al-Rawi.
Thank you, Mr. President. Question number 15 to the Honourable Minister of Finance.
Of Finance.
Thank you, Mr. President. In response to the first part of the question, Mr. President, I have been informed that the total number of persons who paid property tax as of May 2nd, 2025 was 132,124 persons. Response to question number two, part number 2 of the question, Mr. President, the total sum of property tax collected as of May 2025 was $135,534,838.81. Part 3 of the question, Mr. President, the property tax collected by the Inland Revenue Division in its capacity as a receiver of revenue was initially deposited into authorized commercial bank accounts in accordance with Section 53 of the Financial Regulations made under the Exchequer and Audit Act, Chapter 6901. These funds were subsequently transferred to the Exchequer account at the Central Bank of Trinidad and Tobago. Mr. President, a more detailed view of how the property tax was deposited is as follows. Payments made online were deposited into the authorized commercial bank accounts held at First Citizens Bank, FCB, and Republic Bank Limited, RBL. Upon receipt, a process of review and reconciliation was undertaken to validate the payments. Where payments were found to be invalid, instructions were issued to the respective banks for their return to the payer. For valid payments, instructions were sent to the bank to sweep declared funds into the central bank's Exchequer account. Payments made through the district revenue offices and the San Fernando City Corporation were deposited into the authorized RBL account and subsequently swept into the central bank. These payments are later brought to account at the Treasury Division. Payments received at the Port of Spain City Corporation were deposited directly to the central bank, bypassing commercial bank collection accounts. Mr. President, in the case of Tobago, property tax payments were deposited into the Tobago House of Assembly's authorized FCB account. The relevant information was then transmitted to the final account section of the Division of Finance, which coordinated with the Treasury Division to bring the amounts to account. Upon completion of all verification checks, the validated sums were then swept into the central bank. Mr. President, as can be seen, all relevant governance and reconciliation procedures were observed in full compliance with the provisions of the Exchequer and Audit Act and all applicable Treasury regulations. Part 4 of the question. Mr. President, the source of law and authority by which these sums of property tax paid and collected as of May 2nd, 2025 were deposited into the account identified above were derived from the following. 1. Section 13(1) of the Exchequer and Audit Act, Chapter 6901, which mandates that all revenues and other monies raised or received for the purposes of the government shall be paid into the form part of the consolidated fund unless otherwise provided by any other written law. 2. Section 53 of the Financial Regulations made under the Exchequer and Audit Act, which states that receivers of revenues shall deposit all cash, checks, and other monies with an authorized bank for the credit of the Exchequer account. 3. Section 44(1) of the Central Bank Act, Chapter 7902, which establishes the Central Bank of Trinidad and Tobago as the banker for the government, responsible for receiving and disbursing public monies and keeping accounts thereof. Accordingly, property tax revenues collected by the Inland Revenue Division, acting as a receiver of revenue, were lawfully deposited into authorized commercial banks and subsequently transferred to the Exchequer account held by the Central Bank, as required by the legislative framework and Treasury procedures. 5. Mr. President, the sums of property tax paid and collected as of May 2nd, 2025, as distributed across each of the municipal corporations in Trinidad and Tobago, as well as the Tobago House of Assembly, are as follows. Arima Borough Corporation, 4,616. Total payment received, $3,957,841.67. Chaguanas Borough Corporation, total property payments count for corporation, 9,023. Payments received, $11,541,565.55.
Your 5-minute period is up. You may wish to circulate the rest. Senator Al-Rawi, any supplementary?
Thank you, Mr. President, for that very excellent recommendation to circulate the rest of the answer. May I, in a follow-up question, please, relative to specifically Roman 4, the source and authority of authority, the law and authority, would the Honourable Minister please inform whether, pursuant to Part 4 of this question's answer, in law and authority, whether the property tax will continue going forward?
The Honourable Minister, Planning and Development.
Mr. President, pursuant to government policy, this will be eliminated in the future.
Honourable Senator Faris Al-Rawi.
By way of supplementation, in accordance with the answer just received, would there be refunds in respect of payments made as particularized today?
The Honourable Minister.
Mr. President, that matter will be dealt with by the Minister of Finance at the appropriate time, but as far as I am aware, this matter was asked by the Minister of Finance and answered in a subsequent interview.
The Honourable Faris Al-Rawi.
Not supplementation. How is it that the Minister of Finance asked a question which he answered?
Just repeat that for me.
Sorry, Mr. President, the Honourable Minister said that the Minister of Finance asked a question and answered. I'm not aware of that. Could he please elaborate on his supplement?
Honourable Minister, please.
Mr. President, as the Honourable Member would know, the Minister of Finance in the other place was asked a question and answered that question in the other place. He can look up the Hansard report and find the information required.
Honourable.
Thank you, Honourable President, Honourable Minister. In supplementing the questions asked, thank you for your answers. May I please specifically ask whether there will be refunds to be made as an answer in this House? I'm not aware of any question or answer in that House. This is a separate chamber.
If this question has been asked and the Minister is taking full responsibility, it has already been asked and answered in another place. I think the minister is properly responding to your concerns. Well, I think we have exhausted all supplementary questions. Let us proceed. Please, continue. Clerk.
Public business, government business, bill second reading.
Before you go there, isn't there there's a motion? There's something on.
Motions relating to the business or sittings of the Senate and moved by a minister.
The Honorable Leader of Government Business.
Mr. President, I beg to move the following motion. Be it resolved that the Senate agree to the following appointments to joint select committees. 1. On land and physical infrastructure, Ms. Sophia Chote, Senior Counsel, in lieu of Mr. Derup Timal. 2. On foreign affairs, Mr. Anthony Vera, Senior Counsel, in lieu of Mr. Francis Lewis. Liu. Yes, I said Liu. Yes. And 3 on the Public Accounts Committee. I didn't realize that you were an English teacher. Mr. Francis Lewis in lieu of Mr. Derup Timal.
Honorable members, the question is, be it resolved that the Senate agree to the following appointments to joint select committees. On land and physical infrastructure, Ms. Sophia Chote, SC, in lieu of one of Mr. Derup Timal. And on foreign affairs, Mr. Anthony Vieira, SC, in lieu of Mr. Francis Lewis. And on the Public Accounts Committee, Mr. Francis Lewis, in lieu of Mr. Derup Timal. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clerk.
Public business, government business, bill second reading.
Yeah, Attorney General.
Thank you, Mr. President. Mr. President, I beg to move that a bill entitled An Act to Amend the Trustees Ordinance, Chapter 4 of 1939, the Prevention of Corruption Act, Chapter 1111, the Mutual Assistance in Criminal Matters Act, Chapter 1124, the Proceeds of Crime Act, Chapter 1127, the Anti-Terrorism Act, Chapter 1207, the Police Service Act, Chapter 1501, the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, the Income Tax Act, Chapter 7501, the Companies Act, Chapter 8101, the Partnership Act, Chapter 8102, the Registration of Business Names Act, Chapter 8285, the Securities Industries Act, Chapter 8302, the Non-Profit Organizations Act, Number 7 of 2019, to give effect to the obligations of Trinidad and Tobago under the Financial Action Task Force, be now read a second time. Mr. President, in accordance with Standing Order 48-1, I seek the leave of the Senate to debate together with this bill the Counter-Proliferation Financing Bill 2025, which relates to the same subject.
This is the wish of the Senate. Okay. Honorable Attorney General, proceed.
President, for us this afternoon, our debate is on two important pieces of legislation. The Miscellaneous Provisions FATF Compliance Bill 2025 and the Counter-Proliferation Financing Bill of 2025. In the other place, the Counter-Proliferation Financing Bill of 2025 received, as I recall, no objection. The objection was centered on the Miscellaneous Provisions FATF Compliance Bill. And it is that bill that I intend to speak primarily to this afternoon. Mr. President, both pieces of legislation are intended to ensure that Trinidad and Tobago gives effect to our obligations as a member of the international community insofar as financial matters are concerned, and in particular to our obligations as a member of the Caribbean Financial Action Task Force. I would like immediately to put to rest three fallacies that were raised in the other place, and that I believe should help to keep the debate focused on the substance of the main bill. The first is the allegation that we on this side are somehow bringing flawed legislation to the Parliament. Mr. President, we are here to debate amendments to ensure compliance with the mutual evaluation report. I'll just refer to that as the MER for 2026, the mutual evaluation report for 2026. That is a process which was started under my predecessor, either twice removed or my immediate predecessor. I've lost count of exactly what took place when. But in any event, it's a process which began 3 years ago. We are seeking this afternoon in this amendment, Omnibus Amendment Bill, to amend several pieces of legislation, some of which they had crafted, brought to the Parliament, subsequently enacted, others that they never saw it fit to amend over the course of an entire decade. These amendments are required for compliance, either because they were not brought by our predecessors based on previous reports, or because the FATF would have changed their own requirements, which is something that happens from time to time. This is not new. And later on in my contribution, I will provide details on the various pieces of legislation which are to be amended and the dates on which they came into being and were previously amended. So that first allegation is flawed. We are amending because in the ordinary run of things, legislation is always speaking. It requires amendment, either because you have not captured exactly what is required or because circumstances change. The second fallacy that was repeated ad nauseum in the other place, as if repetition of a falsehood could somehow make it into fact, is that we are late with this bill and that we missed a deadline. As I said in the other place, and will repeat here for complete clarity and transparency. CFATF, that's the Caribbean Financial Action Task Force, and colleagues will forgive me if I use the acronyms this afternoon, because the contribution in the other place took 77 minutes. I don't intend to be more than half an hour. CFATF has been in negotiations with the then government since 2022. According to my records, that's 3 years ago, according to my math. I read out a letter from the Attorney General, twice removed, my friend, Reginald Armour, written in September 2023, which is 2 years ago by my math, requesting a deferral for Trinidad and Tobago's MER, Mutual Evaluation Report, for which these amendments are being made. In this correspondence, Mr. Armour was pleading with the CFATF Secretariat 2 years in advance for an extension of this deadline on the basis of the fact that he said the parliamentary term was scheduled to end on or before August of 2025. He wrote that letter in 2023. I don't know what he was seeing in 2023, but he predicted that the parliamentary term would end in August 2025. He also noted that a general election was to be held in 2025 and that the THA would have elections in January 2025. I think there was an error there. What he meant was January of 2026. And he went on to conclude that, and I quote, the timings of these upcoming elections combined with the expected outcomes will collide directly with the timeline for Trinidad and Tobago. I haven't spoken to him about what those expected outcomes were, but we know that the country elected in 2025 a new government. What he was clear about, and what, I don't know if he was a prophet, but what he was correct on was that Parliament was prorogued in August of 2025. His request for an extension was denied by CFATF. Instead of ensuring, now this is 2023, instead of ensuring that the amendments were made as a matter of priority ahead of the time, the previous government demitted office and left it in, well, I would have to say, our very capable hands to do the best that we could do. Mr. President, I met with CFATF. I explained the situation to them. I told them that there was no way that the legislation would be passed by August of 2025, but I did give an undertaking to bring the legislation at the earliest opportunity. And that is why we are here this afternoon. This is the earliest opportunity. Now, I know that my friend on the independent bench, Senator Lewis, was questioning on the last occasion, well, why the citizenship amendment before something else which was more important? Well, and I say this with as much humility as I can muster. People say that I am not whatever. But, Mr. President, it's the business of the government to establish legislative priorities. We brought the citizenship amendment at a time when we felt that our sporting community and our sportsmen required that sort of initiative, we make no apologies for it. But there can be no doubt that the bill which is here this afternoon, I think ticks all of the boxes that Senator Lewis pointed out on the last occasion. Now, the third fallacy that was perpetrated in the other place by, of course, the independents are not in the other place, so I speak squarely to those opposite, my colleagues and former friends and allies. I just have to shake my head this afternoon when I look at what you have become. But the third fallacy which my colleagues immediately opposite raised in the other place was that in making these amendments, we would not be exercising something which they describe to be enough sovereignty. Well, that is something that I think I have to spend some time on, so I'll come back to it in a while. All that I'll say for the time being is that we are part of the international community. First of all, a member of the United Nations. I think the Honorable Prime Minister is there doing our business today. A party to several treaties, and we are part of the FATF global network. Now, more than 200 governments and 20 observer international organizations are involved in this. And unless we want to have a society in which we send money from Port of Spain to Diego Martin or to Carapachima, and not from Trinidad to the United Kingdom, the United States, then we have to play by the global rules of the road. And the FATF and the CFATF are the institutions which set the global rules of the road. So that's all that I have to say at the outset with respect to the fallacies that my friends opposite perpetrated in the other place. Now, I should add at the outset that when in the other place the legislation appeared to be sailing through, a tactic which Senator Swaratsingh and I are familiar with as past members of a club, again, opposite, was thrown out. Send this bill to a joint select committee. Mr. President, I do not wish to bring you into the debate, but as a long-standing member of the House, Senator Nakil as well would know that bills that go into the Joint Select Committee go there for a reason. They go there to take time. And our colleagues on the other side, I'm not imputing improper motives, but our colleagues on the other side know the benefit and the utility of the Joint Select Committee. So I want to say at the outset that the legislation this evening is going to pass, hopefully with the support of all members of the House who are patriots, and without the games that we all know. Those of us on this side, Senator Swaratsingh and I are adept, we are old hands at this game. All of you all of my colleagues on the front bench are well versed in this game, and I would urge members to sit, do the people's work, and as Senator Lewis said, for us to get on with the job that we have before us. Now, I want to, having said those introductory matters, I want to turn quickly to the bill. Mr. President, the CFATF is a member of the Financial Action Task Force. It's an international body which sets global standards to prevent money laundering, terrorist financing, proliferation financing, and the harm that these illegal activities can cause to society. Now, we have been in this business for 35 years. We have been working together with the FATF. In 1991, they were first established. There were 40 recommendations promulgated at the time, which sought to develop a framework for anti-money laundering practices worldwide. It expanded its remit in 2001 in the immediate aftermath of the terrorist attacks to include a new set of guidelines and a set of 8 special recommendations on terrorist financing. And as I say, that was in response to the 9/11 attacks in the United States. In 2005, they included another recommendation to deal with the cross-border movement of illicit funds. 2006, they adopted a new surveillance process, an important one, known as the International Cooperation Review Group, ICRG, which is an institution to identify, examine, engage with vulnerable jurisdictions that were failing to implement effective anti-money laundering strategies and to help to combat the financing of terrorism, AML-CFT. They further revised their mandate in 2008 to indicate that they were going to increase surveillance on systemic criminal and terrorist financing risk, and to enhance the ability to identify, prioritize, and to act on those threats. 4 years later, in 2012, FATF members adopted a revised and updated set of 40 recommendations, which added the proliferation of financing of weapons of mass destruction to the areas of surveillance. In addition, the revised recommendations addressed new and emerging threats and sought to clarify and strengthen many of the existing obligations. The new standards recommended dealt with strengthening and allowing countries to take a more focused approach to areas where high risk remained or where implementation could be enhanced, to significantly strengthen requirements in the area of transparency regarding adequate, accurate, timely information on beneficial ownership, control of legal persons and arrangements to address issues of tax transparency, again tied into beneficial ownership, corporate governance, and various types of criminal activity. In focusing on higher areas of risk and thereby taking a risk-based approach, the FATF sought to encourage countries to identify, assess, and understand the risk posed by money laundering and terrorist financing, and to adopt the appropriate measures to address those risks, providing for a more flexible set of measures for countries to utilize their resources in the most effective way. Now, new standards were put out, and those standards recommended that, one, that terrorist financing should be criminalized. For those of us who have the FATF recommendations, that is recommendation 5, that countries should implement targeted financial sanctions to comply with the United Nations Security Council resolutions, UNSCR, relating to the prevention and suppression of terrorism and terrorist financing. Again, if we have the FATF recommendations, that's recommendation 6. Now, there is in the Office of the Attorney General an entire department which is dedicated to making sure that we are compliant with what UNSCR produces on almost a weekly basis. The standards also recommended that targeted financial sanctions related to the prevention, suppression, and disruption of proliferation of weapons of mass destruction and its financing, recommendation 7, should be implemented. A new feature of the amendments was the requirement to review laws and regulations to ensure that NPOs, non-profit organizations, were not used to finance terrorism. That is recommendation 8. And my colleagues on the other side did enact legislation to treat with non-profit organizations. Mr. President, I labor to give this history to recognize that FATF recommendations continue to evolve. New threats emerge and are observed in the global financial sector. Our individual countries are kept under review at all times. And in our case, it is the job of the CFATF, by a system of peer review, to look at what we are doing and to say, yes, you are doing enough, or no, you are not. So the recommendations operate as a peer review process whereby, for example, in relation to Trinidad and Tobago, CFATF members will review our legislative and administrative procedures to ensure compliance with recommendations. Now, I want to turn to our past reviews. Trinidad and Tobago's first round MER was approved in 1995, second round MER in 2002, which coincidentally was just about a year before I took office. Its third round MER was approved in 2007. I think I left around that time. Our fourth round MER was approved in November of 2015 in the plenary that the CFATF held in Port of Spain. Now, at the time of approval, Trinidad and Tobago was placed in a category, enhanced follow-up process. That was our category, because we had 8 or more non-compliant / partially compliant ratings for technical compliance. We also had a low or moderate level of effectiveness for 7 or more of the 11 effectiveness outcomes. But importantly, we were placed on the ICRG monitoring process. And as a result of the ratings in the 4th round report, the EU included Trinidad on its list of high-risk third countries that presented strategic deficiencies in its AML CFT regime. Now, that meant that all European financial institutions had to apply enhanced customer due diligence when dealing with persons or legal entities established in Trinidad and Tobago. Now, it should be noted that thereafter, Trinidad and Tobago presented a first follow-up report, FUR, May of 2017, that was in plenary for information only. Second FUR, May 2018, plenary for information only again. Third, enhanced FUR, technical compliance, May 2019, plenary. Fourth, 2021, plenary for information only. Fifth, FUR, May 2022, plenary for information only. Sixth FUR, May 2023, plenary in keeping with CFATF procedures for the fourth round of AML CFT mutual evaluations. Now in 2020, we were removed from the gray list. So we were no longer subject, now that's the FATF gray list. We were no longer subject to the FATF's monitoring process. We were removed from the gray list, and that removal mitigated the potential for de-risking by certain banks. Now, that was a milestone achievement. It made clear that we had made substantial reforms, and those reforms had taken place by all of us in this house. And that is why I ask us to do the right thing this afternoon. Now, Mr. President, I've gone to some lengths to explain that the FATF and the CFATF, they are not new things established in 1990. Our work has been ongoing. In the other place, I thought it important to emphasize that our work is not that of any one government or any one administration. There are dedicated public servants who work on these matters all the time, and that we should recognize and appreciate their efforts in keeping us compliant. And I should like now to turn to one of the most important bodies which is entrusted with that. It is the NAMLAC, the National Anti-Money Laundering and Counter-Financing of Terrorism Committee. Now, it's situated in the Office of the Attorney General, but it is manned by personnel. When I say it's situated in the Office of the Attorney General is the point of contact. It's manned by professionals from the Office of the Attorney General, the Ministry of Finance, the Ministry of National Security, the DPP, the Commissioner of Police, the FIU, the Central Bank of Trinidad and Tobago, the Board of Inland Revenue, and the Securities and Exchange Commission. Now, there was legislation by way of an amendment to the POCA, the Proceeds of Crime Act, to make the NAMLAC a statutory entity. That was important and noteworthy. Now, I turn now to our past legislative changes. So I've taken some time, pedantic as it may have been, to talk about the history of the FATF and the NAMLAC, and to give an overview of exactly what we are about today. But what I hope to get across is this, that what we are dealing with is compliance with the rules of the road with respect to international conventions on how we transact financial matters across borders, how we behave as a country affects our standing in the international community. We commenced work on the FATF recommendations in 2000, looking at our legislative history. First with the POCA, the Proceeds of Crime Act, we enacted the Financial Intelligence Unit Act of 2009. We then did the Financial Obligations Regulations in 2010, the Anti-Terrorism Amendment Act of 2010, which was amended to include financing of terrorism. And there have been various amendments to those pieces of legislation since 2009. This is not the first time we are amending as many pieces of legislation as we are in one sitting. And I crave the indulgence of the Senate to spend some time looking at some of those amendments. In respect of the Anti-Terrorism Act, which is 1207, there have been 9 amendments. It was enacted in 2010, amended in 2011, 2012, 2014, twice in 2018, 2019, 2020, 2024. The Proceeds of Crime Act, 17 amendments, 2009, 2012, 2014, 2015, 2016, 4 amendments in 2018, 2 in 2019. Now, I'm trying not to be political this afternoon. We weren't in office in 2018 and 2019. My friends were. But that's a fact. 4 in 2018, 2 in 2019, 2 again in 2020, 2 again in 2021, 2022, and 2 in 2024. So that's 17 amendments, 11 to the FIU-TT. 2011, 2012, 2014, 2 in 2018, 2019, 2 in 2020, 2022, 2024. And that is, I know, there's a similar story, Mr. President, with respect to the Income Tax Act. Well, the Income Tax Act was amended once, Trustees Ordinance twice, Partnership twice, companies a couple times, gambling once. We have not today sought to bring the Virtual Assets and Virtual Assets Service Providers Act. That is coming. We did, my friends on the other side did enact the Civil Asset Recovery and Management and Unexplained Wealth Act of 2019. And there has been important litigation in respect of that act. Now, Mr. President, the beneficial ownership provisions are, well, the beneficial ownership theme is what permeates a number of the amendments today. So that the amendments to the Trustees Ordinance, the Prevention of Corruption Act, the Mutual Assistance in Criminal Matters Act, the Proceeds of Crime Act, the Anti-Terrorism Act, the Police Service Act, the Financial Intelligence Unit Act, Income Tax Act, Companies Act, Partnership Act, Registration of Business Names Act, the Securities Act, and the Non-Profit Act touch on various recommendations in the FATF. I'm not going to carry us through those recommendations now, but they range from the very first, that is recommendation 1, to recommendation 38.8, which deals with mutual assistance in criminal matters. Now, if I could just spend some time on the acts themselves. The Companies Act, the amendments in the Companies Act, seek to prohibit and render null and void any express trust in relation to property or other form of legal arrangement, provide for registration of existing trusts within a period of time, and provision is made for the minister to provide that certain categories of trusts and other legal arrangements are exempt from the provisions of Part 1 of the Act. The amendment also prohibits the appointment of nominee shareholders, and that is in keeping with the theme of the finding out who are ultimate beneficial owners of entities. The Prevention of Corruption Act, there are specific offenses which are consistent with the UN Convention Against Corruption, such as embezzlement, depriving the state of revenue, accepting a bribe, contracts, in relation to contracts, bribery and resisting or obstruction an officer investigating any matter under the Act. The Mutual Assistance in Criminal Matters Act is amended by ensuring that the terms seizure and freezing are included in the definition of criminal proceedings, and for the purposes of a particular provision in the FATF recommendations, it treats with the word communication, introduces the word communication, so as to signal that what is required is the widest range of cooperation. Now, the Proceeds of Crime Act, the POCA, is amended to delete references to specified offense and drug trafficking, and to replace that with criminal conduct throughout the Act in order to take an all crimes approach. Now, the amendment would also allow, importantly, for restraint orders to now be available at the stage of an investigation into an offense, because the Act now only allows for restraint orders to be granted where proceedings have been instituted or proceedings have been concluded under, in respect of applications made under 15 and 17. There are amendments to provide for undercover operations by the police service, which are in keeping with the provisions of the task force. Amendments to the financial obligations regulations, to the regulations that govern the Securities and Exchange Commission, and to the Anti-Terrorism Act. Mr. President, I ask this House this afternoon to examine the utility of the Act, to look at the undoubted benefits which are to be gained from keeping faith with our international partners, and to take heed that the recommendations are all necessary in order for us to comply in relation to the FATF recommendations and to keep to our tight timeline for our MER evaluation in March of 2026. And with those words, Mr. President, I beg to move.
Honorable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Trustees' Ordinance, Chapter 4 of 1939, the Prevention of Corruption Act, Chapter 1111, the Mutual Assistance in Criminal Matters Act, Chapter 1124, the Proceeds of Crime Act, Chapter 1127, the Anti-Terrorism Act, Chapter 1207, the Police Service Act, Chapter 1501, the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, the Income Tax Act, Chapter 7501, the Companies Act, Chapter 8101, the Partnership Act, Chapter 8102, the Registration of Business Names Act, Chapter 8285, the Securities Act, Chapter 8302, and the Non-Profit Organizations Act, Number 7 of 2019, to give effect to the obligations of Trinidad and Tobago under the Financial Action Task Force, be now read a second time. Honorable Senators, you are reminded that leave has been granted for bills numbers 1 and 2 to be debated together. I recognize Senator Vishnu Dhanpaul, but before he begins to speak, in accordance with Standing Order 42, subsection 11, I have granted the Honorable Senator the right to refer and read his presentation. Senator Vishnu Dhanpaul.
Thank you, Mr. President. And as you said, because of the complex nature of these two bills we are debating today, I'll be referring to my speaking notes extensively. Mr. President, thank you for the opportunity to address this Honorable Senate on two interlocking instruments that impact the heart of Trinidad and Tobago's defenses against money laundering, terrorist financing, and proliferation financing. The miscellaneous provision, FATF compliance, and I'd like the Attorney General, Mr. President, I'll use the acronym, Bill 2025 and the Counter-Proliferation Financing Bill 2025. Mr. President, I speak from a position of direct, hands-on experience, building and stress testing the very systems we are debating today. Over the course of my tenure as Permanent Secretary in the Ministry of Finance, I was involved at various levels in the government's anti-money laundering, countering the financing of terrorism, counter-proliferation financing work program. This was done through both UNC and PNM administrations. The work of the team at the Ministry of Finance included steering successive national risk assessment cycles and translating the findings into legislative and regulatory deliverables, updating the proceeds of crime framework and financing obligation regulations, targeting changes to the anti-terrorism and mutual assistance regimes, and early scoping of beneficial ownership reforms for companies, partnerships, and trusts. The team at the Ministry of Finance also oversaw budgetary and capability build-outs for supervision and financing intelligence, helped implement data pipelines and service level expectations for sanctions implementation, beneficial ownership access, and suspicious report feedback, and convened technical consultations with banks and designated non-financial institutions and professions to make sure obligations could be met in practice, not just on paper. The Ministry of Finance was also involved with interagency preparations for international assessments and review milestones, conducted mock interviews, aligning statistics and case studies with immediate outcomes, installing basic dashboards for asset recovery, sanctions and freezing, supervisory inspections, and mutual legal assistance, turnaround times, so that when assessors ask, does it work, the competent authority at the Ministry of the Attorney General could answer with sound evidence. And for that, Mr. President, I'd like to thank the public servants at the Ministry of Finance. Mr. President, the amendments in these bills are not cosmetic. They are the legal rails on which effectiveness must run at the bank counter where screening is conducted, within the FIU of the Ministry of Finance and supervisory authorities when risk-based judgments are made, in the Office of the Director of Public Prosecutions when confiscations are pursued, and ultimately in our courts. Mr. President, these two bills are complex in nature since they make broad, sweeping changes. My opposition colleagues in the other place suggested that the FATF package of legislation should be immediately referred to a joint select committee and not railroaded through the Parliament without proper scrutiny. And as we just heard, the Attorney General was of the view, for some inexplicable reason, that this was a stalling tactic by the opposition. So be it, Mr. President. Mr. President, I want to draw reference to the Honourable Minister of Finance's argument when he piloted these bills in the other place. I will do so by linking each claim to what the bills actually do in law and what the Financial Action Task Force standards require. Mr. President, the Honourable Minister of Finance framed these bills around essentially scope and urgency, noble intentions. He emphasized, among other things, the strengthening of mutual legal assistance to permit freezing and seizure of assets, the calibration of dual criminality for certain non-coercive assistance, recognition of external restraint orders, and cost sharing and asset sharing, important changes aimed at FATF's recommendations 37, 38, and 40. Mr. President, these objectives make sense. But in the fifth round evaluation next year, it would be about measured speed and constructiveness, not just textual coverage. Mr. President, if we want these clauses to count in any assessment, we should legislate service level expectations through some agreed timeframes. In addition, we should publish annual mutual legal assistance statistics, requests received or sent, average turnaround, orders obtained, and values confiscated. This strategy turns aspiration into critically, here, Mr. President, audit evidence under immediate outcomes on international cooperation. These are precisely the kind of rapid, constructive, and effective outputs FATF expects under recommendations 37 to 40. Mr. President, on the transparency of legal arrangements, the Honourable Minister of Finance relied on the Trustees' Ordinance overhaul to require registration of registrable legal arrangements, imposition of deadlines for initial registration and rolling updates, and to mandate core beneficial ownership particulars with penalties for non-compliance. Mr. President, I need to tell this Honorable Senate, the FATF standards are outcome-focused and technology-neutral. FATF's own framing is unambiguous, and I quote from the FATF framework. Countries have diverse legal, administrative, and operational frameworks and different financial systems, and so all cannot take identical measures. The FATF recommendations outlines an international standard which countries should implement through measures adapted to their particular circumstances. That is why effective jurisdictions have chosen different but disciplined paths on beneficial ownership. In other words, Mr. President, one size does not fit all for FATF. Mr. President, the Honorable Senator Swaratsingh will never understand this concept. But the point is not to copy any international model wholesale. The point is to legislate our own access speed standards and digital rails so that competent authorities obtain accurate beneficial ownership data within hours, not weeks, because that is what the fifth round assessment will probe next year. Mr. President, turning to the Proceeds of Crime Act, familiarly known as POCA, the bill modernizes key definitions by clarifying that property of funds extends to instruments such as bearer negotiable instruments and virtual assets, and creates wider confiscation tools aligning the statutory toolkit with complex cross-border cases. These are consequential amendments, but because virtual assets and virtual asset service providers are now a mainstream channel of value transfer, the parameters must be explicit. Mr. President, I'll have more to say on this during the virtual assets bill debate, but it will be interesting to know if the Office of the Director of Public Prosecutions has provided comments on the amendments to the Proceeds of Crime Act, since the amended Act introduces criminal conduct as an all-crime approach. How does this impact current investigations and prosecutions? I am sure Senator Al-Rawi, my colleague, will have much more to say about this in his contribution to the debate. Mr. President, on targeted financial sanctions for terrorism and proliferation, the FATF bill, together with our Anti-Terrorism Act and the dedicated Counter-Proliferation Finance Bill, broadens property to include virtual assets, shifting reporting triggers towards immediate action, criminalizing tipping off, and giving sanctions power to supervisory authorities. Mr. President, to meet the assessor's yardstick under recommendations 6 and 7, and this was mentioned extensively in the minister's contribution, we need to define without delay in law and digitize the entire pathway. FATF's own best practices paper states, and I quote, "Without delay means ideally within a matter of hours of a designation by the United Nations Security Council, and freezing of assets should occur without prior notice. This is the audit benchmark, a statutory definition that anchors without delay to same-day screening and freezing, backed by a 24/7 mechanism for out-of-hours listings, gives institutions legal certainty and gives supervisors a measurable standard. This should be combined with a machine-readable consolidated sanctions list published by the Office of the Attorney General, with an alerting service requiring correction notifications via secure electronic forms. Those small drafting details produce the evidence accessors will test. That is, time from listing to freeze, quality and completeness of freeze notifications, and remedial sanctioning of non-compliance when necessary. Mr. President, let me briefly address the Counter-Proliferation Financing Bill. The explanatory note makes it clear that institutions must immediately report interactions with listed entities, keep specified records, refrain from tipping off, and submit to risk-sensitive supervision with inspection powers, administrative sanctions, and penalties. This is taking the country in the right direction. Agreed. However, I recommend 3 technical enhancements in the bill. 1, define immediately for reporting in operational terms in hours, not days, and with time logs. 2, mandate the supervisory authorities to issue annual sector-specific counter-proliferation financing classification by legal notice or directive. And 3, authorize with confidentiality and protections a privacy-preserving information sharing utility under the Ministry of Finance's FIU oversight, so supervised institutions can exchange information on counter-proliferation financing and complex terrorist financing classifications without breaching secrecy laws. Mr. President, these are not theoretical niceties. They are the practices several jurisdictions use to raise ratings, and that's the key here. And in some cases, to exit increased monitoring after demonstrating stronger targeted financial sanctions, implementation and sanctions for non-compliance alongside improved international cooperation. Mr. President, because the Honorable Minister of Finance relied on the bill's breadth or scope, I want to remind this Honorable Senate about what FATF will actually test in the 5th round next year. Under the updated methodology of June 2025, assessors evaluated 2 interrelated components. 1, technical compliance, that is to do the laws and institutional, do the laws and institutional powers exist? And secondly, effectiveness, that is, do they work and deliver outcomes? The methodology makes it clear that effectiveness is about the extent to which legal and institutional framework is producing the expected results. And assessors will come with risk-based scoping, data requests, and sampling of files. They will be coming here literally fully loaded. That is why service level timelines, digital rails, and published supervisory outputs matter. Assessors will only credit what exists. It should be noted that Trinidad and Tobago will be the first CFATF member country to be evaluated for the 5th round, and the draft report is expected to be considered December 2026. Mr. President, let me now address non-profit organizations. The FATF revised Recommendation 8 in 2016 to clarify the subset of non-profit organizations, which should be made subject to supervision and monitoring. And crucially, and this is very critical here for non-profit organizations, to clarify that not all NPOs are high risk. Our regulations should reflect this fact about NPOs by adopting objective, risk-linked thresholds for enhanced oversight, paired with annual outreach. These approaches both capture real risk, avoid stifling legitimate activity, while assessors will recognize, which assessors will recognize as faithful to the risk-based standard. Mr. President, the core mechanism of the Honorable Minister's case are largely sound, but they will not earn us effectiveness credit unless we hardwire the features that turn obligations into measured outcomes. For trusts and legal persons, specify access and timing and require machine-readable application programming interfaces. That is, API-enabled registered, so competent authorities can query across company and trust data. For sanctions, define without delay as same-day screening and freezing and require 24/7 trigger. Publish a consolidated sanction list in machine-readable form with subscription alert and mandate electronic freeze reporting to the FIU. For mutual legal assistance, codify the 5-day acknowledgement and 20-day filing targets add a same-day fast lane for urgent targeted financial sanctions and counter-proliferation financing matters, and publish annual legal assistance and asset recovery statistics. This is how other jurisdictions demonstrated rapid, constructive, and effective cooperation in their follow-up. For non-profit organizations, keep the regime squarely risk-based, as FATF now requires. Mr. President, two further technical points. First, data quality and unique identifiers. Give the registrar and regulators statutory authority to run validation and mismatch checks, impose penalties for false filings, and adopt persistent unique identifiers for beneficial owners so the same individual is recognizable across companies and trusts. Very, very critical. High-performance systems use this discipline to make beneficial ownership data analytically useful to competent authorities. Exactly what the assessors will test next year. Second, transparency of supervisory outcomes, that is, require supervisors, including the FIU, where it exercises supervisory powers, to publish annual outcomes, inspection coverage by risk tier, breach teams, penalties for material ban with early resolution policies, remediation timetables, and compliance rate. FATF guidance emphasizes supervisory feedback and statistics on property frozen or confiscated assets and on international corporations. Jurisdictions that publish these numbers make the assessor's job easy and their ratings stronger. Mr. President, as an opposition senator, I reject the idea that greater scope alone equals robustness. The CFATF fifth round will credit what works, measured in hours and days, not months and years. This is what FATF asks for in black and white. If we legislate those specifics now, we will give our institutions the tools and the timelines to deliver the outcomes assessors will test on-site and in their follow-ups. Mr. President, the on-site fifth round mutual evaluation is in March 2026. While we'll discuss these bills in detail, clause by clause, allow me to underline what CFATF will look for the minute they land at Piaco. One word, effectiveness. They will test whether our rules and regulations are being applied in real time, not merely inscribed in statute. How are the gatekeepers conducting and documenting customer due diligence? Our targeted financial sanctions list complete, consolidated, machine readable, and actually screened against at the point of payment? When a competent authority requests beneficial ownership information, is it delivered within hours and certainly within one business day? Are suspicious transactions reported moving digitally from reporting entities to the FIU, then analyzed and disseminated in hours or days, not months? When MLA requests arrive, are they acknowledged within 24 hours, progress against clear statutory service levels, and tracked through its execution, tracked through to execution with public performance metrics? Finally, and crucially, do law enforcement, prosecutors, and the courts use these digital rails to restrain and confiscate proceeds swiftly? Mr. President, I'm not a lawyer. I'm not also not even a Bush lawyer. Not yet. But I will say what I said above. That is the difference between expansive law and effective ones. The former filled pages, the latter changed behavior. The fifth wrong assessment will be unforgiving on these points. Sharp time-bound obligations, near real-time access to data, auditable processes, and published service-level performance. If we anchor these two bills in those specifics, we will move from form to function, and it will earn Trinidad and Tobago serious credibility. Finally, Mr. President, the implementation of these bills requires extensive human and technical resources with significant operational measures across all state agencies involved in AML, CFT, CPF. The government has to ensure that the requisite information technology and other administrative systems are in place. Unfortunately, I've been told the government has hindered this move by removing key personnel from the Office of the Attorney General. In this context, the government should take careful note that just yesterday, Standard & Poor's moved our country's outlook from stable to negative, and they can feel free to ignore this indicator at their own peril. Mr. President, and this is in my DNA, just some advice for the government. Standard & Poor's signals economic direction with two tools: an outlook, positive, negative, stable, that usually covers up to 2 years, or shorter for speculative greed, and a credit watch for situations where rating action is more likely in the next 90 days. So while past data may inform the story, the published view and any change reflects where Standard & Poor's thinks this country is headed. In closing, Mr. President, what are the government plans to effect and implement these pieces of legislation? Are the regulators going to be adequately staffed and resourced and provided with specialized training? We have not heard anything about any such plans, but I will say more about SNP during the budget debate. Thank you, Mr. President.
Senator Marlene Attzs.
Thank you, Mr. President. I rise to make some very brief comments to address the substance of the bills laid before us, the provisions of which I think are imperative for the conduct of our national and financial affairs. Mr. President, I first wish to acknowledge the very detailed and thorough contributions made by the Attorney General and Senator Dhanpoul. I think they both contributed to my further understanding of these bills and all of the requirements to essentially give effect, and also some of the complexities involved in the FATF process and also the CFATF processes. Mr. President, I come from a slightly different perspective to both the Attorney General and Senator Dhanpoul. Trinidad and Tobago is a small, open economy. Yet in spite of our size, we are fully embedded in the global financial and trading system. So deeply integrated are we in the financial system, the global financial system, that every day our banks clear payments across borders, our exporters settle foreign contracts, our investors rely on corresponding bank links, and our citizens send and receive remittances. To maintain these essential flows, we must, in my view, adhere to the rules of the global financial game. These rules are not optional. These rules are established by the Financial Action Task Force and, as clearly articulated by both the Attorney General and Senator Dhanpoul, cover anti-money laundering, counter-terrorist financing, and now counter-proliferation financing. This bill, in my respectful view, is not an abstract piece of legislation. It is a safeguard for our economic participation in the world. Non-compliance with FATF standards carries real consequences: higher transaction costs, reputational damage, de-risking by global banks, and I think the Honorable Attorney General mentioned coming off the grey list, and possible isolation from international finance, none of which Trinidad and Tobago would want to risk. For a small island developing state such as ours, with our high level of integration in the global financial system, the stakes are extremely high. Without the level of compliance required by FATF, even routine activities like a student paying tuition abroad, a small business receiving payment for exports, or government settling trade obligations, all of these could be disrupted. The bills before us seek to align our laws with FATF recommendations on countering proliferation financing. Some of the key features are the mandatory reporting and record keeping, which require financial institutions and listed businesses must immediately notify the FUI of suspicious activity or dealings with sanctioned entities. The enhanced supervision, which requires authorities such as the Central Bank of Trinidad and Tobago, TTSCC, to monitor institutions, to enter premises and to ensure compliance. The risk-based compliance programs, which require institutions to design and implement programs approved at the senior management level to mitigate proliferation financing risks. Then there are the penalties for breaches, which attract significant fines up to $5 million. Possible imprisonment. These signal the seriousness of our commitment. Mr. President, while I support the objectives of these bills, I must also raise a concern that arises whenever new compliance requirements are introduced. In his presentation, Senator Dhanpaul correctly said that some of these compliance issues will occur at the commercial bank counter. Inevitably, there is the risk that increased administrative and compliance costs faced by financial institutions may be passed on to the consumer in the form of higher transaction fees, more cumbersome procedures, and additional costs to ordinary citizens and small businesses. All of these can exacerbate the ease of doing business by frustrating the average citizen, but more so frustrating and thwarting the efforts of small and medium enterprises. I suggest, Mr. President, that we therefore guard against a situation where compliance in one area results in an undue burden on the very people the system is meant to support and protect. My hope, Mr. President, is that as a regulatory framework is rolled out, there will be careful coordination across agencies so that compliance in this domain does not mean duplicative reporting requirements or unnecessary transactions costs. In short, we ought to design a policy framework that balances global compliance with local affordability. The law should and must strengthen our reputation abroad while also protecting our citizens at home. To my mind, Mr. President, this bill is more than simply about enforcement. It is about preserving trust in Trinidad and Tobago as a financial jurisdiction. When correspondent banks or international investors evaluate us, they are not only looking at our GDP, our rates of economic growth, they're also looking at whether our systems are robust, transparent, and compliant with international norms. Strengthening our regulation and compliance mechanisms is key to upholding the integrity of our financial system. This ensures that Trinidad and Tobago is viewed as a responsible and reliable partner in the global arena. Despite being a small nation, we honor our obligation to the wider international financial community. That is what compliance with the FATF regulations and our taking on board the recommendations in these bills will signal to the international community. Mr. President, in supporting these bills, we in this chamber affirm Trinidad and Tobago's place as a committed participant in the global financial system. Our citizens deserve the assurance that our country is not vulnerable to sanctions, blacklisting, or reputational damage. At the same time, we must remain vigilant to ensure that compliance does not translate into unfair costs to ordinary citizens. If we get the balance right, then this legislation will stand not only as a matter of global compliance, but as a practical instrument for protecting the economic security and well-being of all citizens of Trinidad and Tobago. Mr. President, with these few words, I thank you for granting me the opportunity to contribute to a matter of profound importance to both this honorable House and indeed to our nation. I thank you, Mr. President.
Thank you. Senator Francis Lewis.
Thank you very much, Mr. President, for the opportunity to present on this. At the outset, I want to signal my very strong support for this bill. There's not a reservation about it, but I want to be open to listening to what my colleagues have had to say, and the presentations so far have borne that out, and they've been very useful. This is a technical bill. We as a country have chosen not autarky, but to link ourselves to the international order. The consequence of that is that we will have to comply, and it is a good thing. Now, we have to figure out how to do it. I'm mindful that passing a law, particularly a law like this, is easy. And as speaker after speaker have acknowledged in different ways, the implementation and the devil is going to be in those details. This is a rare law before this House. This law represents, though it is brought by this government, it represents the work of many, many years of technical and other specialists in successive governments. That makes it rare in the sense of, Mr. President, this is a passing of the torch. And in that spirit, I hope that there may well be, or there's the opportunity, not just for consensus, but perhaps unanimity when we come to voting on this. I have a concern on this bill. It's not in the bill itself. It's a technical bill, and it links with so many other areas. That is not my issue. The issue is, if we don't get it right, what is the ripple effect? And I want to share the concerns there. When we look at, okay, we vote on this bill. Let's assume that it all passes and it's not a problem. It gets proclaimed. It comes down to three big players. It comes down to the financial services sector, it comes down to the regulators, and ultimately it comes down to the people that this bill, this law, is designed to help, to create an enabling environment so they could get on with their lives and do their work. The other thing that I'm very mindful of, and I'm looking forward to it with some enthusiasm, is the upcoming budget, because it's going to set the tone of a new government for where it sees its priorities and where it wants to go. And I think that's a very, very good thing. I would suspect that ministers are still working out some of those details, and that is a good thing. My concern is if we implement this wrong, it could end up having a negative effect on the very economy that we are all committed to improving. If you ask me for a personal goal, right now our GDP growth performance is about 2% a year. I would love us to shoot for 4%. I'd like more, but I wouldn't want to, there'd be concerns I would have about if we went too far, too fast. And that has to happen within 2 to 3 years. And if we make a mistake on implementation, it could take the wind out of the sails just when we are trying to get things going. Therefore, to the points that the earlier speakers made, we got to get this implementation right. Given that, I just want to, it's not a digression, but I just want to say, and this is a very personal view, I have great regard for our financial system. Our central bank is regarded as one of the better ones in the region and in the world. It has performed consistently. We have been blessed with pretty good, and in fact, in some cases, really excellent central bank governors, with perhaps one exception. Our banking sector, please, sorry, I could withdraw that. Our banking sector, we love to talk, and if you go to any group of people and you say, tell me what you think of the banks, or your bank, you would get criticisms, and I think sometimes those criticisms are not balanced with the effectiveness and the performance that those banks provide to the society. Our banking sector, we like to talk about oil and gas being 30, maybe 40% of economic activity to drive GDP growth. Our banking sector provides somewhere between, if I recall the numbers, somewhere between 10 and 15%. That's not to be slighted. They do perform. There are difficulties that they face that something like this will need to be addressed. As my colleague mentioned, there will be costs. How they answer those costs and how they implement will severely affect every policy of the government, not every, but almost every policy of the government, and certainly economic development as we hope it would happen. The concern I have has to do with when we come to putting in regulations to support a law, that sometimes those regulations, if not well thought out, or at least initially, can be very bureaucratic. It can be very ham-fisted. It can be one size fits all. To use a very simple example, the country has somewhere between 25,000 to 30,000 operating businesses. That's the last CSO census that I saw. 80% of those businesses have 5 or less employees. 90% of all businesses operating in Trinidad and Tobago have 10 or less employees. In other words, the vast majority of businesses in this country, with people trying to do their best, trying to get ahead, are relatively small businesses. Their capacity to handle significant reporting compliance requirements is limited. It doesn't help if we start with, we can catch somebody. It has to start with, how do we create an enabling environment so that they can get on with their business, whether small or large. If you're large, you're a conglomerate, you're a business with well over 100 employees, you have the resources, presumably, to be able to devote to compliance. When you're running a business with 10 people, 6 people, 8 people, those resources are the owner who's trying to cover all the bases. And I have a number of colleagues here who run their own businesses, have run it, have grown it successfully. You know what I mean. At the end of the day, all these laws are very, very good. It helps us to link into the international system, but our people have to embrace them. And to that end, I want to call, after the approval of the bill, and I am using this very tail end of my presentation to, I suppose the Americanism would be, Mr. President, to float a trial balloon. Really, it's to indicate, to see whether there will be an interest in this. Perhaps. What could be very useful is a Senate committee for the implementation of this bill. Now, I would want to talk to the respective benches, their leaders, and just explore whether that is something that might be worthwhile. With a very limited life, we're talking, I don't know, 3 months to the end of the year. The key is, how will we make this happen? How we have approached it in the past has been very siloed when we come to implementation, right? So you pass a law, it goes to the regulators talk to the central bank talk to the banks, and that process creates distortion, it creates static. And I think the point that an earlier speaker made about when the next inspection comes, I don't know anybody expects us to be 100% down the road, but they certainly expect to see very real action-oriented progress. So I wonder, Mr. President, whether having such a small grouping, taking the dedicated time to think through not the law or strengthening the particular law, the clauses, but figuring out with the members of the ecosystem how we're going to do this as a country so that it supports the growth, the development, of which the budget is part, for the country. And with that, sir, I thank you very much.
Senator Wesley Gibbings.
Thank you very much, President. I will be extremely brief. There's a bit of serendipity involved here because just 2 weeks ago, my organization, the Media Institute of the Caribbean, initiated a training program for regional journalists on these precise issues, AML, CFT, and is being administered by an agency out of the United States, the AML FC Institute. So actually, I had to break beach from that to attend here last week. But it meant also that this had to be my homework. So I had no choice but to go through this voluminous assignment, even if I'm not usually inclined to do this, because a lot of this involves crossing of T's and dotting of legal I's, and some of that has been proposed here, and I followed some of the deliberations in the other place, and clearly there is the need for perhaps some of that. But that's not that's not the track that I'm taking now. I think in life and in personal life and as a country, there are things you would like to do, there are things you consider you need to do, and there are things that you must do. No question about it. On the question of these bills, we're talking about compliance. We're not talking about something that's culturally relative. Say, well, okay, because we're small and because we're poor or whatever. Though, as Senator Lewis has said in his contribution, there is scope for examining implementation. Senator Dhanpaul raised it as well. Implementation, taking into account the resources at hand and taking into account the realities of life in Trinidad and Tobago, the huge responsibility we have for the small and medium enterprise. And Senator Lewis cited some statistics recently in discussion with the Chamber of Commerce, Trinidad and Tobago Chamber of Commerce. They indicate that 75% of their membership comes from that sector. It's no longer this representative body for the large and wealthy and powerful. So yes, there is this requirement for us to take a close look at how these things are going to work. I think the what is clear, and whether we like it or not, that what is what will guide us in terms of the law and the practice. The how becomes the big question, among the big questions. But some of these issues, in my view, as somebody who's also involved in press freedom advocacy and freedom of expression work, some of it has become quite problematic in other jurisdictions. And some of these other jurisdictions are doing quite well when it comes to the compliance question. We took up the issue of a colleague in Turkey, for example, who was under the anti-terrorism law prosecuted because of his presumed connections with terrorist elements, when his duty really involved writing stories about them and being in communication with them. Contained in these bills are some of those perils as well. Because when you talk about communication and information, and there's quite a lot that deals with information, and we know in our culture, in our background, confidentiality becomes a secret quite easily, at the drop of a hat. A secret that's there to be defended, a secret that's there to be defended by the law with heavy penalties. So I'm seeing in this the possibility or the prospects for repurposing of what is before us, which is rational and understandable, that can have a negative impact on people concerned with communicating to the public. In my circles, we talk about the criminalizing of journalism and the features of the bills that can have the impact of criminalizing the work, the act of investigative journalism. When it comes to disclosure findings, when it comes to interactions with whistleblowers, though provision is there for whistleblowers up to certain levels, but once that reaches the journalists and in turn the public domain, you find that there are heavily punitive penalties that are in store that can have an impact, even a chilling effect, even on the practice of journalism. And we operate in an environment, though you don't have issues such as Mr. Andelegu in Turkey, and you don't have the problem of Maria Ressa in the Philippines, who is someone I know, I've met, and we have discussed. Her issues had to do with money laundering and compliance with tax laws, which were conjured up by the government of the Philippines, which incidentally only recently came off the gray list. So they ain't doing too bad. They're not doing too bad. FATF and the other agencies appear to be relatively comfortable and happy with them. Ditto Turkey, which I think just earlier this year came off the gray list. But these things prevail and they happen. Now, we don't live in an environment where authorities are very fond of turning up at the house of a journalist to haul them to court over some conjured up charge. But there is now, in the current reality, a greater propensity for people to want to know more and to seek out information. The diet for information and communication has grown to a huge extent. So it's not only journalists who operate formally and professionally, but there are other communicators as well. And when you see some of the things that are published in the public space, that are put out in the public space, and some of the responses, the responses of authorities, and you see mention of treason and sabotage and words such as that, you have to be a little fearful about us at some stage crossing that boundary, a boundary that some of us, are sworn to defend. So, as I said, I won't be long. The application of the laws, that's where the action is. That's where the what will become the how. We need to be careful. We need to, perhaps in the follow-up action, as prescribed by Senator Lewis, and I'm very happy and I'm totally supportive of the fact that there ought to be some mechanism for monitoring, for keeping a close eye on compliance and how the legislation unfolds into action, how it unfolds in the commercial banking sector, because Senator Lewis was cautious about going there, but I can go there as a customer. We know what will happen, that there are going to be additional I's and T's in the process in terms of customer relations and what we have to go through in terms of the financial transactions. So I think that there's need for that kind of follow-up. And I think that in the follow-up, one of the things we need to keep in sight would be the impacts on civil liberties, freedom of expression, challenges to the whole thing of public communication, whether informal journalism or otherwise. In some instances, in other countries, people have advocated for explicit protections for journalists. It happened here when we were looking at the Data Protection Act, where, yes, there are things that understandably would require a level of punishment because you have confidentiality involved, you have criminal proceedings involved, and you don't want to compromise some of these things. But you have to be careful when you're going in that direction that you don't have elements of what is being put in place that pose a threat to investigative journalism in particular. Questions of independent oversight, and what do we mean by independence of oversight? Senator Dhanpaul raised the question of the work of the public servants there, and I think that that area needs to be looked at in terms of the resources, not only the adequacy of the resources inside and outside of the public service, but the quality of the resources that are at hand. And I think that there needs to be some ancillary work with other issues. Our Freedom of Information Act, for example, is known more for the breach rather than the practice. Yes, we're better off on a regional, and my organization, we have done a research project on access to information laws in the Caribbean, and Trinidad and Tobago is right up there, probably just behind Jamaica, where their access to information laws are applied very routinely and very stringently and in a very professional manner by civil society organizations and the media. But we need to do more work to ensure that the culture of secrecy that I spoke about before does not seep into a legislative approach to making information, state information more readily accessible to citizens. And I think that there are perils in the bills that we're looking at, that there would be a tightening rather than a loosening of the environment for the sharing of information. And finally, and I'll close on this, I think that there's a strong need for us to engage a process of public awareness so that average everyday citizens have a stronger understanding of the framework, what is there, why it is there, why perhaps some of the people that they interact with, financial agency, institutions they deal with, why they do some of the things that they do. Maybe they overdo it, whatever, but they need to understand that. And for that reason, we engage this task of educating journalists who would in turn now write better stories, more informative stories about some of these processes. So that's as far as I go. I know that there are the I's and the T's, and there is the suggestion that there be some kind of follow-up mechanism to monitor implementation to ensure it's in compliance. And this compliance is a common C compliance in terms of what we want as a society, the kind of society that we want, are separate and distinct from the big C compliance when it comes to FATF and other issues like this. So I want to thank you very much, President.
Minister of Planning, Economic Affairs and Development, and Minister in the Ministry of Finance.
Mr. President, thank you for the opportunity. I'm very grateful to be able to contribute to the debate on these bills. And, you know, obviously, Mr. President, like many of my colleagues, these bills are very technical. And I too have a set of notes, but I wouldn't read from them because I think a lot of these, a lot of my colleagues are able to go through most of it without me having to opine. And like the Attorney General, I did come here as well with no political intent in mind, but Senator Dhanpaul insists on calling my name. So, you know, as he said, that Swaratsingh will copy, I certainly wouldn't copy him. And stand here and speak for 30 minutes and say nothing. Mr. President, please, next time you call my name, I will. But I wouldn't say anymore, Senator Dhanpaul. But the only thing I need to respond to, Senator Dhanpaul, you did raise the S&P report. And, Mr. President, I am very, very pleased to be part of this government that in the time that we have been in office, that we have been in government, under the guidance of the Prime Minister and the Minister of Finance, we were able to maintain the investment grade of Trinidad and Tobago. Notwithstanding that it was because under their tenure, the rating moved from positive to stable, and the fact that it was moved from stable to negative, and the S&P in the report, and you have the report. I don't know why sometimes people are disingenuous. But when you read the report, despite many efforts, there's been only limited outlook, limited progress by previous administrations in diversifying the economy. It goes further to say, anyway, Mr. President, just want to encourage colleagues to please, this report speaks significantly to the economy we inherited from those opposite. In fact, it went on to say, and again, I encourage everybody to read the report, in line with government policy, the central bank has kept, especially in terms of foreign exchange, a quasi-fixed exchange rate since 2016. Since then, the US dollar shortage have dampened economic activity. Since then. So I just want to, when the goodly senator decided that he will raise this in the debate, I'm ready for you too. And we will have an exchange of ideas at that appropriate time. So I wouldn't go on, but I just want to congratulate this administration and my colleague, the Minister of Finance, in ensuring that this country maintain its investment grade. Mr. President, I also have to mention the fact that, and I think a couple of my colleagues would have raised it, but Senator Dhanpaul went on to praise public officers and then praise them on one hand, and then question on the other hand whether they have the ability to implement and execute this. For the last, 30 years, how long we have been at this, and countless of amendments, it is these same public officers who have taken us through many of these reviewed assessments and reviewed sessions to move us to the point where we are on the verge of coming off the grey list and being moved into the black. These are the people who have done it. But the one thing that Senator Dhanpaul referred to is that he said that assessors will come fully loaded, and whether we have the capacity in the AG's office to deal with that, I can emphatically say that if they were there, I too would have that question, but not under the leadership of the Honorable John Jeremie, Attorney General of Trinidad and Tobago. I can assure this Senate, and I can assure the country, and I can assure those opposite, that not under this Attorney General, we will be ready. This Attorney General is a different Attorney General who has his SC well appointed and deserved. The other thing that Senator Dhanpaul asked, Mr. President, and I think in all seriousness we need to address it, is that why we don't send this to the JSC. I am not sure, but maybe the Honorable Leader of Government Business could tell me. Every time we bring a piece of legislation, the first thing any speaker on that side, on the opposition bench, want to recommend is Senator JSC. There has been no FATF amendments or legislation that have ever gone to a JSC. None. So, Mr. President, I just want to, again, like the Honorable Attorney General said when he piloted the bill, please come with a different tactic. This one is getting a bit old. But, Mr. President, as members of the independent bench would have raised, there is great importance to these bills. It impacts our international credibility. It does seek to bring us into compliance. And to use the words of Senator Gibbons, the what is clear. And hence the reason why I wouldn't go into these bills and the different clauses and so on. The what is clear. Consequently, we in Trinidad and Tobago, if we want to continue to be part of the global financial systems, have no choice but to maintain our vigilance and to be compliant in these pieces of, through these bills, to be compliant in what is being asked of us as we maintain our connectedness to the global banking system. Like Senator Gibbons, I too remember, because I was in government at the time when we had piloted the Electronic Transactions Act, the Data Protection Act, and in that time, Ministry of Public Administration and Information was at the center of government, especially in the rollout of the technology, the government's backbone at the time. And I know at one time, Mr. President, you was part of all of that in the Pandey administration. But public administration was the seedbed of rolling out across government the technology platforms that would connect government and make sure that we provided, because when we brought in the electronic birth certificate, that started the age of unique identifiers that we would have used for ID systems and so on. So, but the emergence of technologies across the globe have brought with it a number of new challenges that, in terms of global banking systems, we all have had to be confronted with. But to go back to some of the comments that Senator Attzs and Lewis and Senator Gibbons would have made. And one of the things that I think that Dr. Attzs spoke to, and I think it's very important to note, we could no longer address these things in disconnected units. We could no longer address these things in disconnected parts. We have to understand the effects on the whole, how it affects customers, how it affects the banking system, how it affects the very rules by which all of us have to play by, whether we are in government or in banking. And so it requires a level of coordination, requires a level of sophistication, requires a level of a holistic approach as we seek to implement some of these things. There will be effects, there will be impact. We need to, as Senator Gibbons rightly said, find better ways to communicate some of these things. You know, one of the things that I'm very pleased with in this administration, Mr. President, is that there has never been the level of access, the level of coordination, the level of transparency and connectedness. I don't think that persons, in fact, I know for a fact, because when we visited many of the different chambers and so on, they have said that they have not seen this kind of access and this kind of communication from governments in the past 10 years. And so we have created that connectedness to make sure that as we communicate these things and as we implement these things, that we get from colleagues in different associations, whether it be the banking association, whether it be the chambers of commerce or in AmCham, how the things we do impact the ability to function. And you know, and one of the things that I am very focused on, Senator Attzs, is the ease of business. We need to find ways to make sure that we do not overcomplicate the things we are trying to do. So even as we have to implement some of these things by regulation and legislation and to be compliant with international order, we always have to be mindful of how it impacts on persons who have to use these systems. And we have to find ways to make sure that we work with them to, in fact, I'm hoping within the next couple of weeks that I will be able to take to Cabinet a note to address the ease of business. Because there are many areas where we need to be a little bit more committed to ensuring that rather than retard business, especially when it comes to foreign direct investment, people want to have the confidence that not only are we compliant with the international banking system, but that in all the areas of doing business, that there is a real intent. And that is why this government have signaled that we are very, very serious about making sure that we maintain our compliance, but to do it in a way that is not just coordinated, but to do it in a way that takes into consideration of how it impacts on different organizations and groups within our society. Consequently, when we look at areas, whether it be in some of our regulatory frameworks, in the EMA or the town and country planning, or in the banking areas and so on, we need to be mindful of how we could sometimes retard businesses and people wanting to do business with us and frustrate people from coming to make investments into our country. So while the price of progress is indeed sometimes tedious and hard and can be onerous, these are things we have to tackle. We have to face up to. And Senator Lewis, there aren't any easy ways to do some of these things, you know. And I'm not so sure if we are the competent ones to manage some of those things. But I can say, notwithstanding the one central banker that you may not want to, but I can say that significantly, I have a lot of faith and trust and confidence in the people who have gotten us this far. And under the leadership of those we have here to get us through that fifth round and to be, as Senator Dhanpaul correctly said, the first that will have to go through that. But I'm almost sure that given where we are, and whether it be in S&P, whether it be in the factor compliance, that we on this side are serious about governing. We are serious about taking our country forward. And we will do so mindful of our obligations to all in the society, including groups and persons who want to engage with us in a transparent and open manner. I also agree with Senator Gibbings when he said that there are lots of new behaviors that this seeks to address. I mean, I am always amazed sometimes, and even when we look at our society, and we think in terms of all that is happening in the banking sector, all that is happening in the quasi-banking sector as well. There's so many areas where we have to focus on. I mean, there's so many new ways in which, I mean, people engage with us all the time about wanting to find ways to come and bring foreign direct investment through many different shapes and forms. And when you put it through the asset test, or whether this is bankable, whether this can fit into the central bank system, when you put it through the asset test, you realize and trust me, you get all kinds of emails. And you always have to ask yourself, what are they trying to do in this? What are they trying to suggest? These pieces, these amendments and these bills, really, and there is constant need to keep updating them because these behaviors, as Senator Gibbons said, these behaviors keep changing all the time. And there are even newer things that are coming out. So you have to always find ways to stay current, to stay updated, to stay compliant, and to educate persons as to what is being what is being proliferated outside there. And it requires new approaches. So Mr. President, I want to thank my colleagues for their contribution thus far. And I want to, suggest that, and I think Senator Lewis alluded to it, this is being passed on from administration to administration. All of us want to make sure that Trinidad and Tobago, especially in our banking system, especially in our ability to do business, continue to have international credibility and to have international transparency, and to make sure that we do not do anything here that will make persons not want to be part of our economic system, whether it be through direct investment or otherwise. That remains the concerted goal of all governments, of any government. So hence the reason why this bill is neutral in that sense. But I can tell you that to not do it will lead to disaster. To not take on these provisions and to not support this will lead to disaster. We cannot but do it. And again, to go back to Senator Gibbons, it is how. And as we do this, I think we have to make sure that we maintain open doors, that people are able to be part and parcel of how this is rolled out and impacted in various institutions and organizations. One of the good things about coming back into government is that there are some old habits that we have. And certainly I have learned from the best, the Honorable John Jeremie. We meet with many groups on a weekly basis. We are not the type of government that sits in an ivory tower or that both people who want to engage with us. In fact, I remember when I went to a meeting with the Chamber of Commerce and I asked them after I had my spiel to ask questions, and they said to me that they were a little bit shocked because in the last 10 years, they were not allowed to ask questions. So if there is any government who is prepared to not just be transparent, and I completely agree, I can't remember who said it, but I completely agree that we need to deal with secrecy to the extent that we can, but I completely agree to a collaborative and open approach as we implement this and other pieces of legislation on the impact that it will have on various sectors in our society. But the difference, Senator Lewis, is that I don't know that we have any role in that. We may have, and maybe there may be a time when, through you, Mr. President, that we can have the kind of engagement that will allow us to be updated on how these things are done. And Senator, I open my door to you as the Minister of Planning, Economic Affairs and Development and Minister in the Ministry of Finance. You're free to come by anytime you need an update from what we are doing on that side. But I can't say the same for Senator Dhanpaul. Mr. President. So Mr. President, I too will forego these notes. I am not sure that I could add any value to the definition of the various clauses and the bill as is presented to the Senate, to this Honorable House. But I just wanted to make sure that I put on record our confidence in those who will have to implement this piece of legislation, in the confidence in the Office of the Attorney General, in our commitment to being transparent and focused and open as we implement this and other pieces of legislation. I wanted to also make sure, Mr. President, to put on record that this government will always take what is good and try to implement it in the best ways possible. We accept that this piece of legislation is something that has been worked on over the last number of years by successive administrations, and we will not fail in our duty to take it forward and do our part in making sure that we remain compliant, we remain vigilant, and we keep Trinidad and Tobago's credibility in the international banking system as buoyant and as positive as possible. So, with those few words, Mr. President, I thank you for allowing me to contribute.
Senator Faris, Al-Rawi.
Thank you. Thank you, Mr. President. Mr. President, I propose to dive directly into the bill. And no, I don't propose to be brief at all, Senator Alaha. Mr. President, I thank Senator Swaratsingh for acknowledging that the government stands on the shoulders of those that came before. In recognizing those many shoulders, one of them for me is Senator Vishnu Dhanpaul. It is not every day that one has, as a Parliament and as a Senate, the opportunity to have a former permanent secretary of decades in public service standing who worked with every single government on, in particular as it's relevant today, on anti-money laundering, proliferation financing, and countering the financing of terrorism, contribute to matters this. And Senator Dhanpaul spoke to what is to come, and that is the 5th round mutual evaluation scheduled for March of next year. So permit me to say this. Mr. President, in summary up front, I propose the establishment of a special select committee, not a joint select committee. A special select committee comprising members of the Senate for a very limited time frame. I don't believe that more than 2 to 3 weeks is necessary. And that would be specifically to do what we cannot do today, which is to examine over 120 pages of a bill, which in fact no one has really spoken to in detail because we can't. And also another bill which is being debated at the same time in 40 minutes. If you were to take the 100 amendments to the individual pieces and speak to them for 1 minute, you need more than 40 minutes to speak. And therefore, the sheer logistical outlay of what is required in making law requires us to have some dedicated attention to what we are doing. Now, why do I say this? Mr. President, I've been in the Parliament now for 15 years. 10 of them I participated in government, 7 of them as Attorney General and Minister of Legal Affairs, but 3 of them involved in the LRC, the Legislative Review Committee. And I can say without fear of contradiction that I have participated in the drafting of every single FATF compliance issue in Trinidad and Tobago for 15 years. And this bill that comes today occupies significant concern for me. I want to join with the government in passing this law. Most of it is in good form, the vast majority of it. But there are a few issues that require some more interrogation just for the right answers. Having managed the 4th round follow-up reviews, post-4th round mutual evaluation, I can say that I sat at the table and led the team for Trinidad and Tobago on how to go through a mutual evaluation, and it is not an easy exercise. You must, on this occasion, drive the immediate outcome avenue. So FATF requires technical compliance. That means you have a law, an immediate outcome or efficacy. You must show the law in operation. The 4th round mutual evaluation is now going to the 5th round mutual evaluation. We are the first in the Caribbean Financial Action Task Force to undergo that. And to do it, we must show efficacy of our laws. So on August 15th, 2025, we were required to submit as a country a technical compliance questionnaire where we would have indicated what laws we have in proclaimed state. The government did not miss that deadline of submitting the questionnaire, but it could not, for the obvious reason of these laws not yet being passed, let alone proclaimed, it could not speak to the fact that the laws were proclaimed. The technique which we utilized in passing the follow-up reviews, in getting out of the ICRG, and that is the FATF realm. There's something called the International Cooperation Review Group, ICRG. It assesses you. CFATF has its own ICRG as well. We were in enhanced follow-up with CFATF. We were in the ICRG with FATF. We had to play both avenues at the same time. The joint group of the Americas is going to come here and they are going to interview the government, including all relevant stakeholders, on each of the immediate outcomes. What we must do is we must activate the operationalizations that this bill intends. The Registrar General needs to be collecting beneficial ownership, needs to be demonstrating how many people, the securities industry, the financial intelligence unit has to speak to how many interdictions it did, compliance structures. They have to review the National Risk Assessment document. There are a number of things that we must show. Sometimes one performance is enough, as in the case of Norway in its ICRG review, where they had one conviction and that was deemed to be enough. Now, we're amending 13 laws here. In amending these 13 laws, we have to pay attention. I can undertake and confirm that I have reviewed, Mr. President, I will not demonstrate it, but if I look through the documents that I have here, I have at least 7 inches of paper which comprise the laws that we are amending. That is not a small task. We as a Senate are being asked today, trust me, the technocrats did the work. We do trust and compliment the many hard-working technocrats who I have had the pleasure of working with for a very long time. People like Ms. Ida Eversley of Senior Counsel, the CPC, Mr. Ian McIntyre, Senior Counsel, those at the Securities Exchange, at the FIU. There are excellent people at work, but when we are making law, we need to be very careful, and I can tell you there are cross-reference errors between the financial obligation regulations, the parent laws. There are things that have to be sorted out that I have seen already. How do I know this? Because I'm accustomed to scrubbing these laws, and I can verify verily, I wish to support the government. I have seen these errors. We cannot fix them today. Let me point out, for example, Mr. President, a few issues. Let's go to clause 3 of the bill, the trustees' ordinance. The parameters introduced here at page, the first page of the bill, clause 3, the trustees' ordinance is amended, B, in section 2A. We're deleting subsections 1 and 2 and substituting new subsections 1 and 2. Unless you go to the parent law, which is the trustees' law, ordinance, and physically compare the documentation in the first 1 and 2, you will not spot the formula that is brought now, the jeopardy in the formula that is brought now. I can tell you, Mr. President, when I was at the LRC, I rejected these very formula requests being brought now for a very specific reason. The reason that I rejected them was the old trustees' ordinance that we're now amending now, which we did in 2024. We amended the trustees' ordinance. We inserted a section 2A in 2024. Section 2A says, in 2A1, which we're deleting now, but this is what the law actually is. An express trust or other form of legal arrangement in existence at the coming into force of this section shall, within 6 months of the coming into force, be registered under this act. That's what it says. The bill now says, remove that and put this: an express trust or other form of legal arrangement that is created under the laws of Trinidad and Tobago shall be null and void and invalid unless the express trust or other form of legal arrangement is registered as required under this ordinance. So it upfront creates the nullity provisions in the law, and the law, as it is not amended, specifically says that the process to getting an express trust or other legal arrangement registered is that you must present it to the Registrar General on the prescribed form, you must pay the fee, the Registrar General must consider whether to register it. If the Registrar General does not register it, you have the right of appeal to the High Court, but it does not upfront declare a nullity and voiding. It does so only after the Registrar General makes a determination. Now, why do I make this point? When you go to the trustees' ordinance, the definition of trust is materially important. I don't know if honorable members have had the time to look at this, but as a practitioner in this area of law, I must point it out. Trust, this is the definition from the trustees' ordinance, does not include the duties incident in an estate conveyed by way of mortgage. Great. But with this exception, the expression trust and trustee extend to implied and constructive trusts, and to the cases where the trustee has a beneficial interest in trust property, and to the duties incident in the office of personal representative and trustee where the context admits, includes a personal representative. Three things to pull out of that: implied trust, constructive trust, personal representative. If we upfront declare a nullity in respect of these things, and we don't know what the requirements for registration are beyond a prescribed form that I have not seen, Mr. President, then we are upfront saying you are guilty of an offense for not, in these amendments, registering your trust. But how do you know that you have an implied trust or constructive trust when they are creatures of equity, where a law, by way of equitable relief, will say in litigation, we view this matter to be a constructive trust or an implied trust, or even more particularly, under the provisions of a secret trust, where a beneficiary does not know, where a trustee may not know certain aspects. So, Mr. President, FATF does not require us to necessarily do what we are doing. FATF says, take a risk-based approach, tailor-make it to your situations. So what we were supposed to have today, which is no condemnation of the government, I believe that the government is presently in the saddle, receiving information that it says must be done. I have no condemnation of any ulterior motive on the government's part at all. This is a continuum. What I believe is that we must interrogate the position in relation to, for example, the trustees' ordinance on this point. Because, Mr. President, we are making a nullity and a requirement that cannot be made yet until the constructive trust is declared. So, is it void ab initio? Is it void at the time the court makes the declaration? These are things to be considered. And then, Mr. President, what do we mean by legal arrangement? Now, a legal arrangement is different in law from a legal entity. In a company, for example, you have certain things. In a legal arrangement, you don't have the ability to sue as of right as an arranger, etc. So there are complications. I'm raising that as a flag. There may be answers, but we need to be careful. Why, Mr. President? In securities, in loan transactions, if the underlying matrix of a loan transaction falls apart, sometimes you are bound to pursue it on the basis of a trust, which is a resultant position of a law so held to be applied by a court. In other words, then, in the failure of securities, you may very well find.
Honorable Senators, at this time I'd like to suspend and be returned at 20 past 5. This sitting is now suspended until 20 minutes past 5. The Honorable Faris Al-Rawi, Senator.
Thank you, Mr. President. Mr. President, could you just confirm the time that I must end? Thank you, sir. Mr. President, I was making the point before the break that the trustees' ordinance at clause 3 of the bill is one which I have great concern over. In summary, for those points already made, my concern is that the proposed 2A1, which declares a nullity and voiding of an invalidity of an express trust or other form of legal arrangement, that is something that we must look at in greater detail. The process by which it has to get there is important. One of my colleagues pointed me to a prescription for registration of trusts published by Legal Notice in 2024. I have not seen it, but I thank my colleague for pointing out that the prescription does exist. Mr. President, if I turn to another example of something that concerns me, and let's go to the Mutual Assistance in Criminal Matters Act, and that's at clause 5. The first one that I think is deserving of a little bit more attention, well, let me put it to you this way. I accept the move to all crimes under the Proceeds of Crime Act and in tangential reference back to the Mutual Assistance in Criminal Matters Act. It is actually something that comes from a consultant that we had, Trinidad and Tobago had the advantage of receiving. That's Mr. Alex Ferguson. And that has been put into other laws where you go, instead of scheduled offenses in the Proceeds of Crime Act, you go for all crimes. I think that that is welcomed. When I get to the Mutual Assistance in Criminal Matters Act, MACMA as we call it in practice, the first one that jumps out to me is the issue of dual criminality where there's no coercion. And I think that in terms of confirming the parameters of that, and that is to be found at page 12 of the bill. If I go to page 12, it says, forgive me, that's not page 12. That is, yes, where there is no coercion, forgive me, I can't find the page, but they're saying that the Attorney General, the central authority, which is established under the Mutual Assistance in Criminal Matters Act as the delegatee of the Attorney General in handling requests for assistance, should provide assistance even though there isn't a requirement met, which is for dual criminality. That is, it must be a crime in Trinidad and Tobago as well as a crime elsewhere. Normally, you can't look at it if it's not a crime in both territories. That should not be of any concern because it is a non-coercive aspect of requested assistance. That concerns me in the event that it becomes coercive, because something may start off as non-coercive and then end up as coercive, and therefore that causes concern in extradition matters, where extradition flows from mutual assistance in criminal matters, where it is a mandatory requirement in extradition that you have dual criminality amongst other factors. So I wanted to hear a little bit more about that. If I go to page 12, dealing again with mutual assistance in criminal matters, and we look at the position of paragraph B, that is in section 3, where we say, notwithstanding, this is a new subsection, this new section 3, notwithstanding section 110 of the Summary Courts Act, where a person is convicted of criminal conduct in any proceedings before a magistrate's court, and then it goes down, the magistrate shall, after passing sentence in the case, send the case to the High Court for determination and confiscation. I wondered if this particular clause needed tweaking in light of the amendments that we made to the criminal division, particularly as it is complicated by the Administration of Justice and Preliminary Inquiries Act, where in fact summary offences, or typically magisterial offences, now district court offences, can be dealt with by a high court, but there is the intervening process analysis, to look at the role of the master insofar as a master considers matters and may deal with matters. So I'm not quite sure it suffices to simply say magistrate versus high court when we're dealing with district judge and potentially master as well as high court. I'm not saying it is necessarily wrong, but I think that the flow chart as to the process needs to be looked at in the contemplation of Administration of Justice Preliminary Inquiries Act, which allows for summary offences to be treated with at the same time. And in that act, the AJIPA amendments that we did have a cross-reference to Section 110 of the Summary Courts Act. So I wanted to flag that. When we get to page 17, and we're looking at 45A, Section 45A. When we're at page 17 of the bill, we're looking now at paragraph S as in Sierra, by inserting after Section 45 the following section, subject to Section 3, subsection 3, a person commits an offence if he enters into or is otherwise concerned in an arrangement whereby retention or control on behalf of another person, note the word retention, control another person, criminal conduct, paragraph B, proceeds of the second name. This clause, if I put it in summary, really treats with somebody who is managing the proceeds of crime for somebody else. But I don't know where it starts or where it finishes. I'm quite happy for it. It appears to have retrospect insofar as a situation which exists at the time of the law could be caught. That's very useful in the tracing of assets and in recovery, etc. But I'm sure that there will be legal argument and debate as to the prospectivity of the law, which it usually is, because the law is not deemed to be retrospective normally in interpretation unless you say so and you provide for that. There's no constitutional requirement for that necessarily. If I go, Mr. President, to page 18, and we look at the wording of what is subclause 3. Subclause 3 reads as follows. Where a person discloses in good faith to a police officer or a suspicion or belief that any funds or investments are derived from or used in connection with criminal conduct in any matter or which such a suspicion is based that he, and then it goes A, B, and C. A, did not know or have reasonable cause, etc. B, did not know, suspect, or have reasonable cause, etc. C, intended to disclose a police officer such a suspicion, to a police officer such a suspicion, belief, or matter as is mentioned in subsection 3 in relation to the arrangement, but there is reasonable cause for his failure to make any such disclosure in the manner mentioned at B. It stops there. There's nothing else. So it sets up 3 conditionalities. There is a chapeau. There are 3 conditionalities, but what is missing in law is the chaussure or the shoes to the law that tells you what the consequence of these 3 eventualities are. So something is clearly missing there, and perhaps that may be in the consolidated marked up versions of the law or not. I'm not sure, because we have not seen it. If I go, Mr. President, to MACMA, again, Mutual Assistance in Criminal Matters Act, page 18, and I'm just jumping back to that. If we look at paragraph F, by inserting after section 50 the following section, the marginal note says undercover operations. 50A, 1. No punishment may be imposed on officials competent to investigate money laundering and financing of terrorism who, for the purposes of obtaining evidence related to these offences and tracing of proceeds of crime, perform acts and which might be construed as elements of money laundering and financing of terrorism in connection with carrying out an undercover operation or a controlled delivery. Now, this concept of controlled delivery appears in a number of clauses. It appears in the clause to amend the Mutual Assistance in Criminal Matters Act. It appears in the Anti-Terrorism Act on page 63 under letter O as in Oscar. It appears in the Police Service Act, not with the use of controlled delivery, but by reference to undercover operations. That is at clause 8 at page 77. It also appears at the FIU-TT amendments at clause 9 at page 79, Roman 3. Mr. President, I have asked the Clerk of the Senate to circulate for honourable members a cabinet note produced by the last government, a paper from the Law Reform Commission policy paper. So there's a cabinet note 12 April 2024. It's called Note for Cabinet, the Controlled Operation Bill 2024. I have asked for the actual law which was drafted under the last government to be circulated as well. Now, why have I done that? Mr. President, we acknowledge that our public servants are excellent and have done yeoman service. In fact, I was very pleased to see at the National Awards, one of our public servants, our former head of the Law Reform Commission, Mr. Samraj Harry Paul of Senior Counsel, received an award. He is the same person involved in the preparation of the law reform paper to deal with controlled deliveries. Mr. President, when I was Attorney General, I had the view that controlled deliveries, which is a feature which first occurred and which is part of our law in the Firearms Act, and which is undefined. In the Firearms Act, it says you can allow basically firearms and other things in an international transportation mechanism to flow, and that there would be a different treatment for people involved in that, competent authorities. In other words, then, it's up to the DPP to not prosecute police officers and other law enforcement persons in undercover operations. It didn't exist anywhere else in our laws. And borrowing from the law of the Interception of Communications Act, in particular Section 8 and Section 11 of that Act, I formed the view, let me put it very simply, when you're looking at American television and they patting down somebody in a gangster movie, and they say he's wearing a wire, and they rip open his shirt and they see a wire, meaning he's recording the conversation. Inevitably, you see in the television program, the movie, that person had to go for a warrant from a judge, not only to intercept the communication, but to participate in the undercover activity and be granted immunity. So we developed, and it started under me, something called controlled operations. And when you go to the law which we drafted, which is at the Honorable Attorney General's office and would be part of cabinet papers now withdrawn. When you go to the Controlled Operations Bill, Mr. President, and you note that there has been consultation with the following persons: Trinidad and Tobago Police Service, Trinidad and Tobago Defense Force. When you get to other consultation entities, we go to the DPP's office, etc. All of the consultation points demonstrate that it is important, if you're going to give immunity provisions, that we discipline ourselves by including parameters for granting it. It is dangerous, as we propose in this law. It's a good legislative intention. I share in the intention. But the prescription which we have developed as a PNM government, which is still available for us to consider, because it's being brought into this law now as a sliver, the prescription must involve what the law says in other jurisdictions. And if you go to the law reform paper, which all honourable members will receive from the Secretariat, the controlled deliveries goes through what is a controlled delivery. It goes through what the FATF obligation is in respect of improving investigative techniques. It goes through how we identify and practice. It goes through the caution that you must have the caution against entrapment. And if you remember, Mr. President, when we were doing the law to effectively bug prisoners, we did an amendment in the Interception of Communications Act. We were compelled to have regard to the Bailey principles. And those Bailey principles are against entrapment, notice, etc. But when you go to controlled deliveries and entrapment, and you look at the law in the United Kingdom, you look at the law in Australia, you look at the law in the other parts of the Commonwealth, you go right here to Antigua and Barbuda, all of the laws that treat with the use of undercover operations, the laws that have evolved as a result of constant attack on these types of operations, say that you should provide for a written application to be made to a judge in the High Court, that you should provide for an oral application to be made in urgent circumstances and then put into writing. Stick a pin. We have an example in the Interception of Communications Act. Oral application, Section 8. Written application, Section 11. Provide for general matters to be taken into account by a judge. Provide for additional matters to be taken into account by a judge. Provide the court with power to refuse or grant the application. How you treat with it in terms of secrecy. How you treat with it in terms of disclosure. How you treat with it at trial. Because, Mr. President, we cannot subject our law enforcement officers by the very noble intention that we have in this bill. And, Mr. President, I make no criticism of this government as to the inclusion of these provisions. I am saying that there is material of a deep level of investigation and research which tells us we would have to be off our proverbial collective rockers to agree to include in MACMA undercover operations in the bare form we have, to include in the Anti-Terrorism Act the bare undercover operations provision, to include in the Police Service Act the bare undercover operations, and in the FIU Act as well. How can we as a Senate today agree to that? Mr. President, I give the solemn obligation, if chosen in a special select committee to represent interests, to participate with the government hand in hand to make sure we complete this law in no longer than a 2-week to 3-week period. But these things have to be addressed because we cannot just say we accept the public servant's view. I have demonstrated from first principle and by way of disclosure today a cabinet note, a draft law, the use of judicial permission, the cautions that are required in this type of approach to the law. And that is something that we as legislators have to pay attention today because we are not respectfully in a kumbaya situation of saying, let's get on with it. We are making law today, Mr. President. We're not making a speech. At the third reading and passage, we are making law. Now, does this affect our timelines? I can tell you as a matter of fact, we have up until the 5 o'clock in the afternoon on the last day of the on-site in March to amend and present law. So March 2026, on the 5th day of the assessment at 5 o'clock in the evening is our ultimate deadline date. However, it will be true to say you must show efficacy and effective positions by that. But Mr. President, we cannot allow our law enforcement officers to be paraded in the papers to say, well, this one clandestinely met with this person and making allegations. These things have happened. I won't go into recent events in the papers, etc. But we have to protect law enforcement. More particularly, we have to protect the trial. If our ultimate goal is to have evidence, then we must do that. If we look at the proliferation financing legislation before us, the FATF recommendations, Mr. President, we actually have law that treats with that right now. We have the Economic Sanctions Act. We have the Iran orders. We have the North Korea orders. I amended and piloted the amendments to the Economic Sanctions Act. Why? So that FATF could rate us as being compliant on economic sanctions against proliferation financing. We could argue we have the law. Today we have come to pass a standalone bill on proliferation financing, which I agree with. It's the same way we ought to be piloting a standalone law for undercover operations. Because, Mr. President, unless you have the evidence, you cannot get the conviction. I'll give you a real example. The United States of America had us in Tier 2 and pushing to Tier 3 observation for human trafficking. It's now a part of the all crimes approach, so it's relevant to this bill. We could not get out of Tier 2 watch list because we didn't have one single human trafficking conviction. We had to use the criminal division, Section 24, create a specialist court, and accelerate the prosecution of one matter to show we had one success. If you look to money laundering, which is one of the successes that we must show to the FATF, ICRG observers when they come, the Joint Group of the Americas, unless we have convictions in money laundering, unless we can show evidence of cooperation and mutual legal assistance, unless we can show beneficial ownership has resulted in returns of beneficial ownership, then we will not pass muster. We will fail. The only way for Trinidad and Tobago to pass the 5th round mutual evaluation will be for this entire Parliament to cooperate, and we commit to cooperate, and to march towards showing we have evidence of the operation of our laws. If we don't do that, Mr. President, we cannot pass. Mr. President, let's get to the exceptions of what's coming in the Financial Intelligence Unit Act, the Anti-Terrorism Act. We're amending the financial obligations regulations for the terrorism law, which is 2011, and the FORs for 2010. So FIUTT has financial obligations, they are 2010. The Anti-Terrorism Act has financial obligations or regulations, they're in 2011. Thank you, Mr. President. Mr. President, effectively, in a nutshell, I'm saying these are severely improved and necessary improvements to the FORs, but for listed businesses, meaning every single real estate agent, every lawyer, by way of example, you have to comply with the obligations. Mr. President, when you look to the schedule of administrative fines, which we must have to meet recommendation 35, FATF recommendation 35 says you have to have alternative measures to crimes, administrative sanctions are there. But Mr. President, when you look at the schedule of what is serious and very serious or not serious, and then you're looking to the distribution as to what the administrative penalty will be to purge the liability, Mr. President, it requires greater inspection. We have bifurcated the administrative fines between listed businesses and financial institutions, and then we've graded them in order of size. But right now, Mr. President, we have to be cautious about the proportionality of what we are doing. It's definitely on the right track. It's something that has been long in the making. The last point that I think I have to just touch on, and Mr. President, I want to remind, this is barely an opportunity to scratch the top of the surface of over 200 amendments we're being asked to pass today. Mr. President, look at Section 97A of the Income Tax Act. We're proposing to amend the Income Tax Act. But Mr. President, I don't know where Section 97A has come from, which is giving an express power of the Board of Inland Revenue to investigate and take all such steps in law as it may to call for production of documents, etc. Mr. President, when you compare Section 97A as it's proposed to be put in with the existing Section 97 of the Income Tax Act, and you go to the criminal compliance unit in the Board of Inland Revenue, I don't know that we can just so say that they never had the power to investigate. And I don't know, and I hope that we'll be regaled with it, what the position is going to be with providing powers. Because if the powers are to compel the production of materials, etc., is it with warrant? Is it without a warrant, etc.? What about the conflict in the language between Section 97 as it exists and Section 97A, Mr. President? So, Mr. President, with the utmost respect to this Honourable Senate, having a lot of knowledge in this area, and that is meant to be no boast. It's just saying that I have had experience of the need for caution. I commend the Honorable Attorney General on bringing forward these amendments as he had to. I believe that it is properly a continuity of law. I think respectfully, Mr. President, we need to go to a quick review of it in a special select committee because, Mr. President, I want to support this law. I agree with the Honorable Attorney General that eyes are on patriotism and country first. I don't buy the argument that we're trading our sovereignty. You have to play in the rules of the international world. But, Mr. President, if we fail at the fifth round mutual evaluation, all of us in trouble. No correspondent banking. We're going to be de-risking down our throat. Insurance premiums will go up because reinsurance will affect us. Banking relationships will be cut off. We already have short forex supplies. This government has received a baton. It's carrying the baton now as it must. I will accept that there is bona fide purpose on the part of the government. But, Mr. President, I'm genuinely urging all senators present today to heed the caution that I have offered. Regrettably, I've only had a small opportunity to point to what I wish to. It does not even make sense for me to propose amendments at the committee stage because they will not make sense at this point, Mr. President. I'm respectfully asking the Honorable Attorney General to agree to a short special select committee where we get on with the work extremely quickly. We come back and we have joint purpose. Thank you, Mr. President.
Senator Sophia, Chote, please.
Thank you, Mr. President, for the opportunity to speak. I must confess, whenever I see a bill which starts with the words, the miscellaneous provisions, I look at it with a measure of trepidation, because I know that it's going to be a huge amount of complicated material to consider, address, and digest. As legislators, we find that difficult to do. And I imagine to those who are listening or looking on at the Parliament channel, they too must be wondering at some point, what on earth are they talking about? Because they do not have the paperwork that we have before us, or they may not even have the full digital version of what we are debating. So, in my contribution, I wish to say that if there are those listening or viewing who feel a little confused by what we are talking about, there is absolutely nothing wrong with that. As legislators, when we start off, this is how we start off the exercise, by recognizing that it's a difficult one to perform. I sympathize with any government standing in the shoes of this government, because I have seen my colleagues on the other side standing in your shoes, bringing legislation like this to the Parliament and wanting to get it through expeditiously. When international regulatory bodies say to you that they are coming to do an audit, unfortunately, small jurisdictions like ours need to comply, and we need to comply as quickly as we can. Regrettably, I don't think that we always get it right, I must confess, and I will use how the Proceeds of Crime Act has been addressed in some of these amendments to illustrate my point, perhaps because it is the piece of legislation with which I'm most familiar. Proceeds of Crime Act was enacted in 2000, in the year 2000. 25 years ago, and it has gone through several amendments since that time. And the reason for that, honorable senators and colleagues, through Mr. President, the reason for that is because it was at first absolutely unworkable. So as a country, we were able to boast that we had enacted this piece of legislation, but we got no benefit out of it. Eventually, law enforcement started using it after it was amended, and we were able to begin to charge people for offenses under this legislation. Mr. President, if you'll excuse me. Now, I use this act as an example because what I see in regulatory legislation like this is that we stand here and we talk about our obligations to international bodies and to the banking system and to everybody else, but we don't talk about the impact it has on the lives of the citizens impacted by it, who will be charged with the offenses or not charged as the case may be, who will be investigated or not investigated as the case may be. And the Act provides for two protections, which in 25 years have not produced any comfort or benefit for our citizens. And I am afraid I'm becoming distracted by the movement in the House, I have to say. But with all due respect, the Act provides for two protections. And Mr. President, if I could respectfully, through you, urge the Honorable Attorney General to take these two protections into account. The Act says rules of court must be drawn up to regulate this draconian power you are giving to law enforcement in your legislation. 25 years later, no rules of court. The Act says when you are dealing with proceeds of crime, have a parliamentary committee set up for oversight over the operations of law enforcement, to which you are giving very draconian powers. I searched, and I could be wrong. There's no such committee. So I'm saying I accept that in certain circumstances we must have draconian laws. But what I am saying is it is very easy for us to fix the problem. Let us ensure that rules are set up. Let us ensure that a committee sits. We don't need to do much because the law says this is what we must do. Now, I'll tell you why I bring this up today, and it is because the failure to do this has had an impact on the judicial system. We have a plethora of cases now coming before the courts, not simply engaging magistrates, but engaging the High Court, engaging the appellate courts. And these courts have to take time to deal with cases like these because the courts now have to read into the Act basic principles of fairness and proportionality because we don't have rules and we don't have oversight. If we can have rules in and we can have oversight, I suspect we can make a dent in the challenges, the legal challenges to the Act that we see. And as far as I understand it, that must be a good thing. Because then the citizen coming before the court knows and understands the process he or she has to meet. The citizen is entitled to take advice accordingly, and then the act of the judicial officer is less likely to be challenged. People will challenge what they cannot understand. So it is for us as legislators to ensure that our citizens understand the court system and the processes which are engaged. So to support my submission, and just to put aside any consideration that I'm making up all of this, I just want to place on the record 3 cases which senators may want to look at if they think that I am imparting something which is incorrect. As recently as 2024, the appellate court had to deal with the case of Clark and Sergeant Singh, Magisterial Appeal 40 of 2024. Gilal and the Attorney General is being sued. Civil Appeal 274 of 2017, DPP and Her Worship Cardinals Raghunandan, Civil Appeal 73 of 2016, and I can go on and on. It's a phenomenon which is occurring in the legal system, which we as legislators can correct. But before I take my seat, there is one thing, Mr. President, I wanted to say, and actually it was the Honorable Senator Swaratsingh who gave me the idea, because I thought he put it simply: we need to know which rules we play by. And I agree with him. We need to know which rules we play by as legislators, and citizens need to know the rules we play by. There is one thing I want to flag, and that is to say, this proposed amendment in Section 45A, this new Section 45A, which basically says that a citizen will not be liable to charge if they make a false report based on a suspicion. Quite frankly, I find that absurd, not to put too fine a point on it, because we know how communications are done in the digital world. You will have someone put up a post on social media, and then you will have comments on that post, and even worse, you will then have comments on the post without some people actually reading the original post. So it is the way in which suspicion can now be formed in our world is beyond what we can imagine. And this is why I say, it seems to me that a person may form a suspicion by reading a post of a post of a post, report it to a police officer. That person has a big car, so it means he's money laundering. You have a post on a post on a post, goes to a police officer, puts someone and his whole family and his whole reputation and life's work in jeopardy, and that person has nothing to answer for under this act. I can't see why that would be necessary, and I certainly cannot see why that would be right. So, Honorable President, I'm respectfully asking the Honorable Attorney General to take that into account, because it is extremely dangerous in our current environment. And Mr. President, with that, thank you for the opportunity to speak.
Is anyone from the opposition who would like to speak again?
Yes, please.
Honorable.
Mr. President, I thank you for the opportunity today to engage in what I have found to be a generally constructive debate surrounding the Miscellaneous Provisions FATF Compliance Bill and the Counter-Proliferation Financing Bill. Now, I'm not here today to excoriate the government. I am entering this debate in a spirit of cooperation because, Mr. President, I recognize the importance of this bill. The government very commendably has brought, particularly the Miscellaneous Provisions FATF Compliance Bill, to amend 13 other bills, and that's no easy task. And in an era with illicit financial flows, no financial system can rest on its laurels. We need to act. But, Mr. President,
The devil is in the details. And when I heard Mr. Lewis use that phrase, I said, my God, this man read my mind. Because when I was going through the details of this bill, over 100 pages, that is detail in truth. But we must do the work. We must ensure that we pass bills and we are not engaging in a hollow exercise. And we have to ensure that when we pass the bills, our institutions are not stretched beyond capacity and the fundamental rights of individuals are not breached, and that we engage in a public education exercise. So those are the things I would like to touch on during my contribution. Now, Mr. President, we in the opposition have long recognized the importance of bills to address money laundering, counter-proliferation, and terrorist financing. We know of the corrosive effects, especially of money laundering. And for the benefit of the viewing public, I will just mention a few of the harmful effects of money laundering because, as Ms. Chote has indicated, Senator Chote, sometimes the listening public may be wondering, what are we really talking about? What we hear about? What is this really about? So money laundering. One of the harmful effects of money laundering is the unfair competition and distortion of markets. Individuals who engage in money laundering may use front companies through which they then transfer or transmit their illicit funds. And by doing that, they may be able to offer services and goods at a lower price than legitimate businesses can then do. So that distorts the market. Money laundering can lead to corruption and institutional erosion. When money launderers are able to build up themselves economically, they then have the power to influence employees in government business. Essentially, they can now engage in bribery, they can capture the regulators and law enforcers. With more money, they can do that. And over time, you have a vicious cycle where the invisible hand of illicit money bends policies. So now the money launderers essentially can become in charge of what drives the policies of a country. We have financial instability because money launderers can cause large sudden shifts in capital, especially if the funds are illegal. So that can lead to destabilization of financial institutions. And I want to develop the others further. Obviously, we have erosion of public trust. One I would like to mention is the loss of tax revenue, because tax evasion, that is a crime. And money launderers use the money that should have ended up in the coffers of the government to fund public ventures, fix our roads, build our schools. The government now does not have that money to use. So money laundering may seem like an abstract concept, but it affects you and I, it could affect you and I. So as it relates to the negative ramifications of proliferation financing, those are obvious. We have threats to international security and global stability because it's all about funding, generally speaking, weapons of mass destruction, the production and dissemination of weapons of mass destruction. That can also lead to a threat to financial and system integrity. Proliferation financing tarnishes the reputation of financial institutions and jurisdictions that become associated with these illicit activities. Now, Mr. President, in addition to the deleterious effects of money laundering, terrorist financing, and counter-proliferation, the opposition is also very much aware of the negative ramifications of non-compliance with policies that have been effected by bodies such as FATF to counteract the scourge of money laundering, etc. And I heard the Honorable Attorney General said, point blank, these are global rules, we must comply. And while I agree with that statement, I do know that the Attorney General sought to dismiss the concerns that were raised by the opposition in the other place surrounding the sovereignty, the term sovereignty. And I know other senators would have essentially joined with the Attorney General agreeing with something we agree, we have to comply. But I don't think we can so easily dismiss the concern surrounding the concept of sovereignty, because the imposition of FATF policy and direction on developing countries has been recognized by as a global concern. Now, Mr. President, I had here lined up a quote from a book, Global Anti-Money Laundering Regulation, Developing Countries Compliance Challenges. And as soon as I stood up, I logged myself out of my book. But if I can paraphrase what the excerpt was, it was essentially saying, now this book focused on African countries, right? But it was essentially saying that FATF rules and rules about anti-money laundering we have an asymmetrical relationship between the rules that were applied and the countries that have to accept the rules. These rules are basically being imposed on us by the North, large multicultural, large multinational organizations, without us having an input in the genesis of the rules. So when I saw the quote, I said to myself, we could switch out Africa and just insert Trinidad, because essentially that is it. We did not have a say. FATF was the genesis of the G7. We had no say. We had to comply. And we accept that. But we mustn't just dismiss the concern. We have to comply, and we have to comply without acknowledging some limitations that may come with that, because some of the amendments that were included in the bills that we are here to debate seems to be acceptance of the recommendations of FATF without any suitable adjustments for Trinidad. One or two, not a lot. So as I said, we should just bear in mind that when we are accepting recommendations, we should really think about the context of Trinidad and Tobago. So turning to, or just continuing on what I said of the opposition recognizing the effects of non-compliance. Dr. Attzs would have gotten into what can befall us if we don't comply. So I don't need to get into that again. She highlighted de-risking, isolation from international financing, higher transactions costs. She outlined that. And as Senator the Honorable John Jeremie, he pointed out, which we all know, we were once on the grey list. In 2017, Trinidad was on the grey list, which means we were under increased monitoring. However, thanks to the hard work of, and I would want to in particular point out Senator Al-Rawi and the technocrats at the time, because of the hard work of these individuals, we were removed from the list in 2020. So we don't want to go back there. The opposition does not wish for us to return to the grey list. So with the upcoming 5th round mutual evaluation to be hosted in March 2026, we understand the urgency for these bills. We do. And the government is right to say that legislative foundation must be laid before this evaluation. However, though we unequivocally support the objectives of stronger laws, that doesn't mean there should be blind acquiescence. It is still our job to, as Senator Al-Rawi said, we must carefully examine the laws that we are being asked to pass here. We must also understand any societal impacts of the laws that we are being asked to pass. So I just want to take some time to highlight a couple concerns, less so with the content of the act, because I think that was addressed by some senators gone, but maybe the impact, focusing a bit on the impact. So these concerns that I pointed out, again, is not about blocking the bill. It is just a matter of identifying some food for thought, okay? So my first concern is the gap between the proclamation of the law and the actual practice of the law. So it was said by a few speakers before me that for FATF, compliance will not be judged by what laws we pass by, but how we implement the laws. How effective we are at that is what we are being judged by. They're looking at meaningful outcomes. How many things have been confiscated, how many people have been charged, tried, found guilty, how many suspicious transaction reports, actual outcomes. And to do that, throughout this bill, we have now imposed on many public institutions new burdens, if I want to put it that way, new expectations. We're asking them to carry out new duties. And we're asking them to do that, but I haven't so much heard about how we're going to assist them with doing that. I haven't heard much about the staff they'll be required, the training of the said staff, the infrastructure, the technology. Senator Dhanpaul was speaking about technological rails, right, and general oversight. By way of example, in the miscellaneous provisions FATF compliance bill, if we look at clause 6, it inserts a new clause 55G in POCA, which requires the supervisory authority to monitor financial institutions or listed businesses and empowers the supervisory authority to take necessary measures on a risk-sensitive basis to ensure compliance with AML, CFT, and CPF laws. Sounds simple. It sounds like that's what they have to do. Makes sense. But when I took a look at the FIU website, Mr. President, do you know how many listed businesses we actually have? The list that I found had over 152 pages of listed businesses and non-regulated financial institutions. I think it was about, 30 or 40 a page. So I'll leave you all to do the maths. But that is the amount of people we are now asking the FIU or the supervisory authority here to monitor. It's not as easy as it sounds, especially given the capacity of these institutions. So the question here is, will the government allocate sufficient budgetary appropriation to match these expanded mandates? That is what I would like to know. And this is a serious concern, especially in light of the reports I read in the local newspaper today about the fact that our credit rating has been downgraded, that the outlook, and that our credit rating can be downgraded as early as next year. It's not like the Calypso that says, my friend, money ain't no problem. It's quite the opposite. Money seems to be a problem, but we're asking more of our institutions. Then another question in relation to this expanded mandate. What timeline for hiring, training, and operational building out? And then seriously, can our judicial system actually handle the volume of cases that we should expect from these new penalties and offenses? Lots of new penalties and offenses have been created through these amendments. Supposing we have had the actual proper training of the police and everybody else involved, can we actually deal with the cases in a timely fashion? So, as I was saying, operationalization of the Act is what is important to FATF. Real-time effectiveness and not just having the statutes on the books. That is what we should focus on. My second area of concern is the private sector compliance burden and the defensive reporting that may emerge from that. So the bill rightly places some new compliance obligations on private sector actors. But quite frankly, some of these obligations will be quite burdensome for some of these actors. If we look at Clause 4 of the Counter-Proliferation Financing Bill, for example, Clause 4.3, it says there now that every financial institution or listed business shall pay special attention to and report all business transactions with individuals, corporate persons, financial institutions in and from other countries which do not comply with or who comply insufficiently with the recommendations of FATF. They have to report complex and unusual or large transactions. They have to examine the background and purpose of all transactions with no economic or viable legal purposes, keep and retain records relating to financial activities, develop and implement a written compliance program, monitor compliance. Mr. President, is a lot. Senator Lewis would have spoken about businesses that have 6 or 8 persons in a business. Mr. President, as an attorney at law, what about sole practitioners? Practically. Sole practitioners, I mean, it's only themselves or themselves with maybe a clerk or a secretary. These sole practitioners, for example, already have the burden of undertaking all of their legal work, so they have to draft all their, do all their research, draft all their pleadings, draft all their submissions, all the court appearance, consultations, briefing clients. Then they have administrative duties that go along with having a sole practice, emails, phone calls, paying this bill, running, and you might have a clerk. But still, if your clerk is at Registrar General, you will have to do something else. And now on top of that, we're asking them to undertake the duties here as outlined in the Counter-Proliferation Act. Mr. President, small and medium businesses, including smaller banks and accountants and lawyers, they will struggle to comply with what they have been asked to do, to buy or create new systems, monitoring, staff, technology. There's both a financial and other costs attached to that. And it's not only smaller businesses, one-man operations. Even larger businesses will feel the impact of these new obligations. Because if we look at Clause 14 of the Miscellaneous Provision FATF Compliance Bill, it is an amendment of the Securities Act. And in there, it speaks to the financial obligation of registrants who now have to have audited annual comparative financial statements that have to be accompanied by a report of an auditor. They have to have interim, and I've lost my page. They have to have interim financial statements, and these filings are in addition to the other requirements they already had. That is going to cost. I have not ever had to, I never paid for audited financial statement, but I'm sure any professional who's doing it, it's gonna cost. And these costs might be passed on to the consumers, or it might just kill smaller players in the market. In addition to those costs now, we have a lot of heavy fines and penalties. So it says here, anyone who fails to comply with requirements of compliance programs or mandate, or the mandate to report suspicious activities, is liable to an exorbitant fine. That is clause, if we look at clause 12 of the Counter-Proliferation Financing Bill, it says there that those who do not comply can face a summary conviction of a fine not exceeding $2 million and imprisonment of a term not exceeding 2 years, and on indictment, a fine not exceeding $5 million and imprisonment not exceeding 7 years. Then clause 12.3 goes on to speak to administrative fine not exceeding $1,750,000, which can apply notwithstanding any summary penalty that may apply. And this can be done by the issuance of a notice requiring the listed business to comply with the relevant provisions of the regulation and pay the applicable administrative fee, which I just said can be up to $1,750,000. And it says that this notice is without prejudice to any proceedings to which the notice applies. So that means actually a person can face both the administrative fine and the criminal penalty. Now, yes, we want these huge fines as a deterrent, but it can have another effect. It can cause some of these individuals to do what is, well, they're just going to report everything. I don't want to get catched by any penalty. I am reporting anything that could possibly be a suspicious activity. So then now, the FIUTT and other supervisory authorities will be inundated with low-value volume, making it harder for them to actually detect true red flags, patterns, or serious transactions. So actually, this over-reporting will now actually make the system more ineffective. So I just want us to become aware when we impose one thing, we may be trying to address one harm, but causing another. My last concern really speaks to dissemination of information, public awareness, and a public awareness. So we are passing statutes. That's one thing. We're making sure, but are we making sure that the regulated entities, the professionals, the society at large understands the changes that we're trying to make here? Because poker has been existing. Poker, as the Proceeds of Crime Act, has been in existence for over 25 years. Today, we are passing amendments, or we are making amendments that introduces this new concept of administrative fines. We didn't have those before. So Clause 6 of the Miscellaneous Provisions FATF Compliance Bill introduces administrative fines, which then necessitated the creation of a schedule which speaks to materiality of contravention of a regulation of the financial obligations regulations. And then it had another section that speaks to calculation of the administrative fines imposed on a listed business. It's a whole new concept, looking at the schedule and how the materiality was defined. Even as a person who would have been involved with poker and understanding anti-money laundering, it's a whole new world that they would have to become accustomed to. And if we want to make the system effective, it's not about saying, well, put the fine, and if they can't cope, they can't cope. We want to assist those who have to comply with complying. Again, that places a new burden on the FIU to engage in workshops, seminars, issuing guidance and policies. Again, another burden on them to assist the system. And then I think Senator Gibbings would have spoken about it, ensuring that the public understands these obligations. Because if we look at the amendment to Regulation 16, there's an amendment to Regulation 16 in poker, which mandates now that financial institutions and listed businesses are required to acquire the name of each director, verify the identity of the director, the full name, the customer, certificate of incorporation, a whole long list. So of course now they have to ask, banks for example, have to ask their customers for this. And when you speak to people about what the bank is asking of them, they say the only thing they ask for is blood. That's how people feel. But it says, you see, the thing is, people just don't understand why the banks are asking for this. So again, a public awareness campaign is necessary. And again, that imposes a financial obligation on the system. So I think I have expressed some of the concerns succinctly enough. I don't want to belabor and keep us here longer. Somebody already warned me, it's Friday, eh? So let me sum up. These are some concluding remarks, right? Mr. President, I'll just read it straight, get to the point. We in Trinidad and Tobago are at a critical juncture. The world, that is the international community, the financial markets, FATF evaluators, they will be watching us closely, because we have said time and time again, March 2026, we are the first ones up for evaluation. So we cannot afford to fall back in the category of vulnerable jurisdictions. Our economic sovereignty, reputation, and developmental prospects depend on us staying off any kind of gray, black, blue, whatever list. Having said that, lawmaking is not a zero-sum game. It's not about government versus the opposition. Here we have a duty and we have an opportunity to perfect the legislation rather than merely rubber stamping. Because somebody repeated it over and over. I think it was Senator Lewis. We have to get this right. We should get it right at the first time and the first opportunity. So let us not have the spectacle of a well-intentioned statute gathering dust because of underfunding of the institution. Let us aim to have a regime that is tough on crime, but fair to citizens, that does not shelter those who seek to abuse gaps in the law and implementation, but also does not inadvertently financially abuse small businesses. If we do this, then in March 2026, we will stand before the FATF not merely with pages of new statutes, but with evidence of institutions transformed. And with that, I thank you.
There's no one else. I couldn't get to the general.
Mr. President, I want to thank each and every one of the members of the Senate this evening for what has been an uncharacteristically civil and productive debate. It has been a civil and productive debate. Now, when I say each and every member of the Senate, what I always mean is the independent bench excluded. Because the independent bench is by definition civil. It is my colleagues opposite who sometimes engage in armed, well, sometimes not armed, but they engage in combat. There was no combat this afternoon, but there was a lot of, unfortunately, there was a lot of misinformation, and it falls to me to deal with that, to deal with that now. Now, if I may be permitted, Mr. President, to seek to treat with the contributions in the order in which they were made. I tried to take notes as I was going along. Sometimes that was not entirely successful, especially in the case of my friend, Senator Al-Rawi, who sometimes speaks at a rate and at a pitch which, you know, is difficult for me to follow. But I'll do my best. So, in the case of Senator Dhanpaul, well, first of all, he started off by reminding the House of his vast experience in this field, unparalleled experience in this field. Those are my words. Those are my words. I prefer to be a bit more understated, but Senator Attzs in the back is an economist of very high repute. Senator Al-Rawi has carried a torch in respect, whatever you might think of him. Senator Al-Rawi has carried a torch in respect of this matter that few of us who have sat in this chair have managed to carry. Now, Mr. President, I have had 20 years experience in it. I'm not saying anything about that, but I have actually taught at Cambridge, and I've taught at the school that Senator Al-Rawi sends his people to learn FATF and AML compliance issues. I haven't seen Senator Dhanpaul there as yet, but I haven't seen Senator Al-Rawi there. I mean, I'm pulling your leg. But so that I take the point that I'm not sure if it was you or Senator Dhanpaul who lamented the fact that we have had a recent loss from the Office of the Attorney General, and that person is someone who frequents the Cambridge Symposium, but she has perhaps gone on to other pastures, and I wish her well. Now, in respect of the substance of what Senator Dhanpaul said, he said, I think, Senator Dhanpaul made the point that when we are assessed, it will be on basically what we have done, and that the assessment is going to be rigid to use my words. And that is true, but we have done quite a bit, and I don't mean only in respect of the passage of legislation, which is what I think the point you were making is that the assessors look not only at what you have on the books, but on how you are implementing the law. So we have made significant progress legislatively, but we have also made significant progress in terms of administration, and we have had an important prosecution in the legislation, with the recent legislation which was passed in 2022, the Civil Asset Recovery. The Civil Asset Law. There's been a decision in the High Court, a reversal in the Court of Appeal, and the matters are awaiting determination in the Privy Council. Now, the decision, the case has thrown up some difficulties with the law, and those difficulties have been addressed here. I'm not sure that you have, that you have spoken to those difficulties. Maybe you have not seen them, but the difficulties have been addressed here. Now, you did speak about targeted sanctions, beneficial ownership, mutual legal assistance, work in progress. You made a point which I didn't quite grasp on the UNSCR, United Nations Security Council resolutions. Now, yes, there is a requirement that the state party must take action without delay. But, I mean, there are nuances to that. And in the case of a person who is in Afghanistan, and this is factual. In the case of someone who is in Afghanistan, if we are asked to act, we act quickly, right away, within hours. But our system is such that there is a distrust of office holders. In some countries, the Attorney General will simply write, and that will be the end of it. We have to go to court. And that is not something that can be done in a matter of hours all the time. In the vast majority of time, that is done within the space of a day. That is how the anti-terrorism unit operates in the Ministry of the Attorney General. So if you get a notification from UNSCR, the application is made to the court and action is taken within the course of a day, which is within hours. But if we live in a society in which you don't trust office holders, and I make no, perhaps that is justifiably so, then you have to understand that the checks and balances that we put in must be respected. And those checks and balances in this case require us to approach the court. The Attorney General cannot write whatever. Now, and I'm not sure that you understand that there are different designations, so that in the case of the one which is, I think, being spoken of these days, TDA, Trin de Aragua, that's not a UNSCR matter. So the designation, we make the application to court, as soon as we can. That does not mean without delay. Doesn't mean that we do it the same day. If we have 2 or 3 to do, that will be done. It just will not be done in one day. And there are other institutions which fall within that category. So it's a little more than simply saying that, oh, the world is going to come to an end because we cannot act without delay. We do act without delay in the vast majority of cases. I would say 90% of the cases where the UN tells us to act. Now, you spoke about the fact that the MER, the assessment will be unforgiving, and that, well, again, the form is not what is important, it is the function. I think I've dealt with that. So it is not simply the legislation, it is how we act. And I think that we have not a perfect system in place, but we do have a developed system in place which complies, which meets muster with our international partners. Now, you did speak of the human, technical, and other resources which are required to push the law along and to make us effective. And the NAMLAC, in my view, is functioning well. There is room for improvement. Senator Lewis made an important point which I intend to, and I give my word to the Senate this evening, that I will be in touch with the Minister of Finance, who should be here any minute now, to establish a body to see exactly how the laws which we have to implement, notwithstanding the comment and the commentary made by my former student, Janelle John Bates, but there is a need for us to look at precisely how the law is being implemented and the effect of the law on ordinary persons and ordinary institutions. I accept that point. It is a very valuable point, and it is something that I intend to take up with the minister. Now, in terms of Senator Attzs, I think that, as I've said before, your contribution was a joy again to listen to this afternoon. You spoke of, you were clear-eyed in terms of what we needed to do, and essentially, I think your support, born of experience, I would hate to age any of us, but your support, born of experience, is welcome. This is something that is required of us, and something which we absolutely need to do. Senator Gibbings, on your point, your concerns about confidentiality and journalism, that is spot on again. And all that I can say is that as a lawyer, I have seen, and I'm sure that Senator Al-Rawi and Senator John Bates Senator Beg will agree with me, that we have seen hundreds of years of precedent and practice eroded by the new reality, which requires us in some cases to act as police officers with respect to our clients. So it is no longer a case of, and I'm so sure that Senator Alaha will bear me out on this. Yes, there's such a thing called client-attorney confidentiality, but that principle, established over hundreds of years, is no longer absolute. The banks are asking for more and more information. Before I left private practice, I was being asked to provide invoices from clients. So the banks now want to know who my clients are. That is quite a stretch for me. I have attempted to, without success, to rally the Law Association when I was in practice, but this is the new reality. And it is not only lawyers, it is journalists are not affected as yet. So you can sit down and relax for a bit longer. But we've been affected, and of course, financial institutions have been, the banks and financial institutions have been terribly affected. Those principles which govern banking confidentiality, they've all been but destroyed. So again, that is a cost of doing business in the new reality. Now, Senator Al-Rawi. Now, with respect to the recommendation that this go to a select committee, I have to say that the bill is not going to go to a select committee, and it's not going to go for this reason. Well, for a number of reasons. One, the deadlines do not permit it. Two, no FATF bill, none, whether you've been in charge of dealing with it, whether I have done it, whether former Attorney General Ramesh Lawrence Maharaj has done it, has gone to a select committee or a joint select committee. We've all been under the same type of pressure. Now, that's not to say that we cannot break with tradition. It's just to say that I want to know what makes what we are doing this evening so different to what we've done before in terms of time. And you have made some points. Now, I say that, and before you spring up and you say, well, the Global Forum bill went, you know that, as I do, that has nothing, that's not an FATF piece of legislation. It is tax, and there's something else, factor, not FATF, tax as well. Both went to joint select committees or select committees. No FATF bill has gone. Now, the points you've made with respect on, well, in my note, I put it as this: is the law perfect? And of course, no law is perfect. Otherwise, we would not be amending law. We won't be amending the law this afternoon. There'll be no need for any amendment to legislation. But the the real point, you're pointing out some problems, some of them which I agree with in technical terms, as was Senator Chote, who I have not got, well, she spoke after you. But there are a couple answers. The laws are always speaking, and if we discover that something is unworkable, this is the Parliament. Our job is to fix things which are unworkable. And if I could just remind you, and I'm not throwing stones here, but some of these pieces of legislation, I hope that's not Senator Cummins who said yes. You know, I'm trying my best this evening to behave. You all fellas, you guys know that I am a well-behaved person generally, right? Better keep quiet. Okay, so there have been sometimes 17, okay, in one case there were 4 amendments in 2018 to the Proceeds of Crime Act, with which Senator Chote spoke about. 4 amendments in the space of 1 year. I saw something looking like 11 amendments in the case of, I have 5 to the Securities and Industries Act, 4 in 2018, 2 in 2021, 2 in 2020. So the legislation is, we amend the law when there are serious problems, if we have timelines to meet. That has always been our practice. We are not oblivious to the fact that this is a democracy and that ultimately we answer to people. And that if people are affected, real people are affected, then we have to fix the law. So in respect of the typographical errors, those could be what we call typographical errors. Those could be dealt with, as you know, by the Law Review Commission. In respect of the errors of substance, if they require further legislative action, I commit to further legislative action, keeping our deadlines, bearing in mind the fact that the minister in the Ministry of the Attorney General is traveling to Panama on Sunday or Monday to attend a CFATF meeting in Panama, at which he will have to report on this legislation. Now, with respect to the other laws, the controlled operations that you spoke about, you would not know, but the TTPS has asked us to hold on that. Okay, there are some issues. It's a national security issue. There are some issues on it. They've asked us to stop work on that, and we have. So we are continuing to work with them. We understand what the problems are, and as soon as practicable, the Senate will be hearing from us on it. Now, with respect to Senator Chote, yes, those rules of court problems. I remember, and I was talking about the Gypsy and Chaitan case, which is how old? 26 years old, when that, I see the President of the Senate smiling. It's a decision of Justice Delaware. We had no rules to govern election petitions. At that time, I was a very, very young junior counsel in it. And basically what Delaware had to do is to make up say, well, okay, I'm looking at the High Court rules and this is what I am doing. And this, it's also the case in the Gilal case, which you said was one of my, that is my case. I think that was one of the last cases I did before I came in to this house. It's still a waiting decision, but I'd like to see what the court does on it. So that is a problem. It is an unfortunate problem. I took a note on it, and I took a note on the point that there is a need for us to develop some sort of working group to oversee this legislation. Of course, you know that I don't practice on the criminal side, so that my experience will be on the civil side. But we have problems on the civil side as well. I am going to commit again to this house this evening to do something about the rules in the legislation and about setting up a committee, an oversight committee to deal with the problems as they arise. And I think that is it. I enjoyed the contribution of Senator John Bates. I do not agree that we can have the sort of widespread consultation that you are speaking about in respect of this type of legislation. The NAMLAC is established to do exactly that in respect of stakeholders, but by the time it gets to us, that is seldom possible. So, Mr. Speaker, Mr. President, I'm back and forth. Mr. President, with those few words, I beg to move.
Honorable Senators, the question is that a bill entitled An Act to amend the Trustees' Ordinance, Chapter 4 of 1939, the Prevention of Corruption Act, Chapter 1111, the Mutual Assistance in Criminal Matters Act, Chapter 1124, the Proceeds of Crime Act, Chapter 1127, the Anti-Terrorism Act, Chapter 1207, the Police Service Act, Chapter 1501, the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, the Income Tax Act, Chapter 7501, the Companies Act, Chapter 8101, the Partnership Act, Chapter 8102, the Registration of Business Names Act, Chapter 8285, the Securities Act, Chapter 8302, and the Non-Profit Organizations Act, Number 7 of 2019, to give effect to the obligations of Trinidad and Tobago under the Financial Action Task Force, be now read a second time. Those in favor say aye.
Aye.
Those against say no. I think the ayes have it.
Act to amend the Trustees' Ordinance, Chapter 4 of 1939, the Prevention of Corruption Act, Chapter 1111, the Mutual Assistance in Criminal Matters Act, Chapter 1124, the Proceeds of Crime Act, Chapter 1127, the Anti-Terrorism Act, Chapter 1201, the Police Service Act, Chapter 1501, the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, the Income Tax Act, Chapter 7501, the Companies Act, Chapter 8101, the Partnerships Act, Chapter 8102, the Registration of Business Names Act, Chapter 8285, Securities Act, Chapter 8302, and the Non-Profit Organizations Act, Number 7 of 2019, to give effect to the obligations of Trinidad and Tobago under the Financial Action Task Force.
Honorable Senators, the Honorable Attorney General.
Mr. President, in accordance with Standing Order 66-1, I beg to move that the Miscellaneous Provisions FATF Compliance Bill 2025 be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honorable Senator, the question is that the Miscellaneous Provisions FATF Compliance Bill 2025 be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The Senate will now go into committee of the whole to consider the bill clause by clause. Advise me when you are ready.
Yes, Chair.
Yes. Honorable Senators, there are no amendments before this Honorable House. As such, with your leave, I am proposing we take all the clauses collectively. Senator Al-Rawi.
Thank you, Mr. President, for the recommendation. I have a few questions that I'd like to ask for elucidation on the record, but ought not to detain us too long in respect of a few of the clauses. Actually there are only 13 clauses. Could we perhaps take them one by one? 1 and 2 obviously are not a problem, just jumping straight to clause 3.
You have questions on all the clauses?
On a few of them, Mr. President.
Would you like to identify them?
On clause 3,
3,
clause 5,
5,
clause 7, clause 8, clause 9,
9,
and clause 10.
and close. All right, so we'll take the first two.
Clauses 1 to 2.
The question is that clauses 1 to 2 stand part of the bill. The question is that clauses 1 and 2 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 and 2 now stand part of the bill.
Clause 3.
The question is that clause 3 stand part of the bill. Senator Al-Rawi.
Thank you, Mr. President. Mr. President, if I may, through you, just ask the Attorney General for an understanding with respect to clause 3B. This is on the first page of the bill in Roman 1, where we delete subsections 1 and 2. The new 1 proposes that we declare the nullity and void and invalidity, voidness and invalidity up front, as opposed to after the Registrar General's refusal under the old or existing 2A. The question I have is, why are we declaring the nullity up front? And if we are doing that, how do we treat with the situation of implied and constructive trusts?
Okay. So we've deleted 1 and 2. 1 is spent already. I think the time for registration expired in when?
Yeah, 6 months has passed. Yeah.
14th of April 2025. So it's been replaced by 2 clauses, both of which declare that the clause will be null and void. Right. If it still exists, unless the
It's registered.
yeah, unless it is registered. So that's it.
Thank you, AG. What I'm driving at, and perhaps you can assist me here, is so unless something is registered within this particular time frame, unless something is registered, unless a trust which is registrable, either an express trust or a legal arrangement, unless it is registered within subsection 1 and subsection 2 within those time frames, it's null and void. My problem with this, which I'm trying to wrap my mind around, is how do we treat with a constructive trust which is determined by a court ex post facto after the time frame? It was never registered. So let's say you go to court and the court determines there was a constructive trust or an implied trust in existence in the case of litigation as at X date, because it's going to state it is retroactive, but it is not registered. The court is therefore denied the opportunity to uphold the validity or even declare the trust, because in law we've said it's void ab initio. It's different from what existed before, where we would go through a process of registration without a declaration of nullity up front.
So the section, Senator Al-Rawi, speaks to express trust, not constructive trust.
But the definition of trust in the ordinance specifically captures implied and constructive trusts.
Perhaps, but that is not what this section is about. This section is about express trust. It doesn't say trust and leave the expression to be interpreted in accordance with general provisions. It says express trust. And that express you, I don't want to use the Latin.
Got you.
But if it's expressed, then...
So AG, I don't propose to, I know we're not going to debate. I'm just putting it on the record for a mark point, because I'd like you to consider it. You gave an undertaking, per se, to have a look at things as the law is continuously speaking. So I've raised it in the context of marking what my concern is for inspection, because this is something that I genuinely was in a loop of trying to understand the constructive and implied trust positions because of the reference to the words or other legal arrangement. And that is the conundrum that I was in trying to make sense of what it means. I know what the FATF methodology of a legal arrangement means, but it's not expressed in our law. So I'm just putting it on the spot, and I don't suppose that we could solve it now.
Okay.
The question is that
so sorry, so Mr. Chair, that was the first one.
No, is that not?
So clause 3 has several aspects to it, Mr. Chairman. I referred to clause 3, paragraph B, and I dealt with that.
Senator Al-Rawi, I'm a Democratic chairman, but I want us to follow the rules.
Which are?
There are no amendments before this Honorable Senate. And to detain the Senate in terms of a conversation between you and the Attorney General, I think it is a bit unfair to the Senate.
Mr. Chairman, could I have your guidance on this? In my small 15 years here, I have constantly seen and witnessed questions of the type that I am asking, because committee stage allows discussion not only on an amendment, but on the clause that is put. This clause is being put, and I have a question.
No. I understand the point you're
Thank
making.
you.
I am given some elasticity, but we cannot go on forever. And as I'm saying also, you're correct to some extent, but expressly speaking, you must put amendments to the floor so that all members of the Senate can in fact be privy to your thinking. But when you alone is putting forward concerns, you put the whole Senate at a disadvantage, and the conversation is between you and the Attorney General. So all I'm saying is that while I'm prepared to give you some elasticity, I'll have to get in, and when I find it's going too long, and rule accordingly. So I'll give you the opportunity to intervene again and seek your clarification. Continue, Senator Al-Rawi.
Thank you very much, Mr. Chairman. Just to confirm, this is just on page 3, at the bottom of page 3. The definition in this section, competent authorities, has the meaning assigned to it by 57A1B. Just a flag, perhaps this is something to be picked up in revision. Just to confirm that that is in fact the correct cross-reference. Nothing more than that, AG. Mr. Chairman, I have no other questions on clause 3.
Thank you, Senator Al-Rawi. Honorable Senators, the question is that clause 3 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 3 now stands part of the bill.
Clause 4.
The question is that Clause 4 now stand part of the bill. The question is that Clause 4 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 4 now stands part of the bill.
Clause 5.
The question is that Clause 5 stand part of the bill. Senator Al-Rawi?
Forgive me, Chair, I have no questions on 5. It's Clause 6 that I have the question on. Thank you.
The question is that Clause 5 stand part of the bill. The question is that Clause 5 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 5 now stands part of the bill.
Clause 6.
The question is that Clause 6 stand part of the bill. Senator Al-Rawi?
Thank you, Mr. Chairman. If I could refer you to page 12 of the amendments proposed in Clause 6 to poker, and 12 specifically in subsection in B, in Section 3, the amendments proposed. In light of the Administration of Justice Preliminary Inquiries Act, a JIPA, I'm just asking for a second look at the process flow between Magistrates Court, High Court, particularly when the matters are consolidated. So therefore, it may be a High Court judge dealing with a summary matter and not a magisterial district court judge, as a matter of fact. So I didn't know if that needed some further attention. I'm flagging that for consideration, perhaps at a later date, as a concern.
Honorable Attorney General?
We're open to looking at it at a later date, Chairman.
Honorable Senators?
And Mr. Chair, just to confirm, there are just a few, I think there's one other, which is at page 17 and page 18. There are two other comments or questions. So at page 17, do I have your permission, Mr. Chairman?
Yes.
At page 17, Mr. Chairman.
Yes, continue.
Well, I had asked this in debate. I don't think it's necessary to put it again. I had a question on the new section 45A, so I'll just move as to that retrospectivity concern. The one that I'm looking at is at page 18, and I'm wondering if subsection 3 is missing a choiseul, or is it that it is an indent that is in the wrong place? Comma.
It's just a comma.
In subsection
after
C.
B, after but, sorry.
So that'll take care of in writing. Okay, thank you. And then at page 18, the last one, T as in tango, inserting after section 50, this is the undercover operations. No punishment may be imposed on officials competent. Insofar as we had an LC largely compliant for this, not fully compliant, I believe. My question is this controlled operation in its very tiny form right here? My own view is that it really ought to be a standalone law because it's missing the immunities and conditionalities of the judiciary's warranting process. So I'm flagging that, in fact, if I were to say it this way, if these clauses on undercover were not in the bill, I would probably be saying yes to the bill now. My fear on the inclusion of these clauses on the undercover without a judicial warranting process, I'm honestly very fearful of how it's going to be operated. So I'm not sure if these are required for FATF's compliance, because I didn't see it in the interpretive notes or positions. I like what they want to do. My own view is much like the economic sanctions was taken over by proliferation financing, that it should be in a standalone bill. But for this, and Mr. Chairman, perhaps I could anticipate now, it would be the same comment I'd make in respect of where else undercover operations occurs in the proposed amendments. This one in particular is the one that I'm very concerned about. So I'm not sure if there's room to excise it and come in a full bill, or if it's required, but without going into any debate, just to mark the spot, AG, to have a look at it. I would love to support it, but this is sort of a poison pill.
It actually is in the FATF recommendations, and and it can't come out, but I take your point about a separate standalone piece of legislation. That's required. It's just run into some difficulties.
Then, Mr. Chairman, insofar as that...
stay.
Thank you, Eugene. Insofar as that would cut and paste into some of my other concerns, the only other concern I had for the record here would be on the Income Tax Act. So at least for me, for my part, I would just say I'd repeat those concerns for wherever else they appeared in other clauses, but not necessary to necessarily traverse them insofar as I've said them now with your permission. So if you wish, and subject to others not having any questions, those would be my submissions until we get to, I believe, Clause 10, which is the Income Tax Act.
Okay, thank you. The question is that Clause 6 stand part of the bill. The question is that Clause 6 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 6 now stands part of the bill.
Clauses 7 to 9.
The question is that clauses 7 to 9 stand part of the bill. The question is clauses 7 to 9 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 7 to 9 now stand part of the bill.
Clause 10.
The question is that clause 10 stand part of the bill. Senator Al-Rawi.
Thank you, Mr. Chairman. Mr. Chairman, my reading of the Income Tax Act, Section 97, is that there already exists investigative powers set out in Section 97 to compel, etc. My question on Section 97A is the need for an express statement that the board shall have the authority to investigate any offences. Is this being done because there was a flag as to caution as not having an express power? It wasn't brought to my attention before. Perhaps it was in the new June regulations or guidance notes produced. But is this really required? And if so, why?
Okay, so the board undoubtedly has investigative powers,
Correct.
but the powers are amplified and made clear in sub A, sub B, and sub C. There are powers to take and record statements from persons, including but not limited to taxpayers and so on and so forth, and those are required.
For the record, I support the board having power, but I had not come across the need for it. So you're saying that this was a spotted lacuna which we were asked to address?
Well, the language in the FATF is the widest range of investigative powers.
Thank you.
This is what other territories have done.
Thank you.
Any further questions?
No, sir. No more on the bill.
Okay. Honorable Senators, the question is that clause 10 stand part of the bill. The question is that clause 10 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 10 now stands part of the bill.
Clauses 11 to 15.
The question is that clauses 11 to 15 stand part of the bill. The question is that clauses 11 to 15 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 11 to 15 now stand part of the bill. Honorable Senators, the question is that the bill be now reported to the Senate. Those in favor say aye. Those against say no. I think the ayes have it. The bill will now be reported to the Senate. The Honorable Attorney General.
Mr. President, I wish to report that the Miscellaneous Provisions FATF Compliance Bill 2025 was considered in Committee of the Whole and approved without amendment. I now beg to move that the Senate agree with the committee's report.
Honorable Senators, the question is that the Senate agree with the committee's report on the Miscellaneous Provisions FATF Compliance Bill 2025. Those in favor say aye. Those against say no. I think the ayes have it. The Honorable Attorney General.
Mr. President, I beg to move that a bill entitled An Act to Amend the Trustees Ordinance, Chapter 4 of 1939, the Prevention of Corruption Act, Chapter 1111, the Mutual Assistance in Criminal Matters Act, Chapter 1124, the Proceeds of Crime Act, Chapter 1127, the Anti-Terrorism Act, Chapter 1207, the Police Service Act, Chapter 1501, the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, the Income Tax Act, Chapter 7501, the Companies Act, Chapter 8101, the Partnership Act, Chapter 8102, the Registration of Business Names Act, Chapter 8285, the Securities Act, Chapter 8302, and the Non-Profit Organizations Act, Number 7 of 2019, to give effect to the obligations of Trinidad and Tobago under the Financial Action Task Force, be now read a third time and passed.
Honorable Senators, the question is that a bill entitled An Act to Amend the Trustees Ordinance, Chapter 4 of 1939, the Prevention of Corruption Act, Chapter 1111, the Mutual Assistance in Criminal Matters Act, Chapter 1124, the Proceeds of Crime Act, Chapter 1127, the Anti-Terrorism Act, Chapter 1207, the Police Service Act, Chapter 1501, the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, the Income Tax Act, Chapter 7501, the Companies Act, Chapter 8101, the Partnership Act, Chapter 8102, the Registration of Business Names Act, Chapter 8285, the Securities Act, Chapter 8302, and the Non-Profit Organizations Act, Number 7 of 2019, to give effect to the obligations of Trinidad and Tobago under the Financial Action Task Force, be now read a third time and pass. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Division, Mr.
Division
President.
is called.
Mr. Allaha,
Yes.
Mr. Jeremie SC,
Yes.
Dr. Swaratsingh,
Yes.
Mr. Maharaj,
Yes.
Mr. Batiste,
Yes.
Mr. Alexander,
Yes.
Mr. Ratiram,
Yes.
Professor Prasad,
Yes.
Dr. Chaitan Maharaj,
Yes.
Mr. Baig,
Yes.
Mr. Zakur,
Yes.
Mr. Naked,
Yes.
Mr. Jack,
Yes.
Mr. Rashid,
Yes.
Archbishop Graybook,
Yes.
Dr. Brown, Mr. Al-Rawi SC,
Abstain.
Mrs. Roberts Rajman,
Abstain.
Mr. Dhanpaul,
Abstain.
Mr. Cummings,
Abstain.
Mrs. John Bates,
Abstain.
Ms. Chote SC,
Yes.
Dr. Attzs,
Yes.
Mr. De La Bastide SC,
Abstain.
Ms. Joan Simmons,
Yes.
Mr. Lewis,
Yes.
Mrs. Lalit Etienne,
Yes.
Mr. McNish,
Yes.
Mr. Gibbings,
Yes.
Ms. Phillips,
Yes.
Mr. President, the results of the division are as follows. 23 senators voted for, there were no senators voting against, and there were 7 abstentions.
Honorable Senators, the result of the division is as follows. 23 members voted for the bill. There were no opposition to the bill. There were 7 abstentions. The bill is accordingly approved.
A bill entitled An Act to Amend the Trustees Ordinance, Chapter 4 of 1939, the Prevention of Corruption Act, Chapter 1111, the Mutual Assistance in Criminal Matters Act, Chapter 1124, the Proceeds of Crime Act, Chapter 1127, the Anti-Terrorism Act, Chapter 1207, the Police Service Act, Chapter 1501, the Financial Intelligence Unit of Trinidad and Tobago Act, Chapter 7201, the Income Tax Act, Chapter 7501, the Companies Act, Chapter 8101, the Partnership Act, Chapter 8102, the Registration of Business Names Act, Chapter 8285, the Securities Act, Chapter 8302, and the Non-Profit Organizations Act, Number 7 of 2019, to give effect to the obligations of Trinidad and Tobago under the Financial Action Task Force.
The Honorable Attorney General.
Thank you, Mr. President. Mr. President, in accordance with Standing Order 48.3, I beg to move that a bill entitled An Act to Provide for Implementation of the Recommendations of the Financial Action Task Force with respect to measures to counter proliferation financing, to make consequential amendments to the Economic Sanctions Act, and for related matters, be now read a second time.
Honorable Senators, the question is that a bill entitled An Act to Provide for Implementation of the Recommendations of the Financial Action Task Force, FATF, with respect to measures to counter proliferation financing, to make consequential amendments to the Economic Sanctions Act, and for related matters, be now read a second time. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clerk.
A bill entitled An Act to Provide for the Implementation of the Recommendations of the Financial Action Task Force, FATF, with respect to measures to counter proliferation financing, to make consequential amendments to the Economic Sanctions Act, and for related matters.
The Honorable Attorney General.
Mr. President, in accordance with Standing Order 66-1, I beg to move that the Counter-Proliferation Financing Bill 2025 be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honorable Senators, the question is that the Counter-Proliferation Financing Bill 2025 be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause.
Chair, I'm ready.
There are 14 clauses in this bill. Do you have any areas you'd like to raise in particular, Mr.?
No, sir. We fully support this bill.
Okay. All right, so we will, with your leave, I'll put the question and I'll put the clauses collectively. Okay? Go ahead.
Clauses 1 to 14.
The question is that clauses 1 to 14 stand part of the bill. The question is that clauses 1 to 14 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 14 now stand part of the bill. The question is that the bill be now reported to the Senate. Those in favor say aye. Aye. Those against say no. The bill will now be reported to the Senate. The Honorable Attorney General.
Mr. President, I wish to report that the Counter-Proliferation Financing Bill 2025 was considered in Committee of the Whole and approved without amendment. I now beg to move that the Senate agree with the committee's report.
Honorable Senators, the question is that this Senate agree with the committee's report on the Counter-Proliferation Financing Bill 2025. Those in favor say aye. Aye. Those against say no. I think the ayes have it. The Honorable Attorney General.
Mr. President, I beg to move that a bill entitled An Act to Provide for the Implementation of the Recommendations of the Financial Action Task Force with respect to measures to counter proliferation financing, to make consequential amendments to the Economic Sanctions Act, and for related matters, be now read a third time and passed.
Honorable Senators, the question is that a bill entitled An Act to Provide for Implementation of Recommendations of the Financial Action Task Force, FATF, with respect to measures to counter proliferation financing, to make consequential amendments to the Economic Sanctions Act and for related matters be now read a third time and passed. Those in favor say aye. Aye. Those against say no. I think the ayes have it.
Division, Mr. President.
Division.
Mr. Alaha?
Yes.
Mr. Jeremie SC?
Aye.
Dr. Swaratsingh?
Yes.
Mr. Maharaj?
Yes.
Mr. Batiste?
Yes.
Mr. Alexander?
Yes.
Mr. Ratiram?
Yes.
Professor Prasad?
Yes.
Dr. Chaitan Maharaj?
Yes.
Mr. Beg?
Yes.
Mr. Zakur?
Yes.
Mr. Nakib?
Yes.
Mr. Jack?
Yes.
Mr. Rashid?
Yes.
Archbishop Grayberg?
Yes.
Dr. Brown?
Yes.
Mr. Al-Rawi SC?
Aye.
Mrs. Roberts Rajman?
Yes.
Mr. Dhanpaul?
Yes.
Mr. Cummings?
Yes.
Mrs. John Bates?
Yes.
Ms. Chote SC?
Yes.
Dr. Attzs?
Yes.
Mr. De La Bastide SC?
Yes.
Ms. Jones Simmons?
Yes.
Mr. Lewis?
Yes.
Mrs. Etienne?
Yes.
Mr. McNish?
Yes.
Mr. Gibbings?
Yes.
Ms. Phillips?
Yes.
Mr. President, the result of the division are as follows. 30 members voted for, no members voted against, and there were no abstentions.
Honorable members, the result of the division is as follows. 30 members voted for the bill, no members voted against the bill, and there were no abstentions. The bill is accordingly approved. The Honorable Leader of Government Business.
A bill entitled
An
Act to Provide for Implementation of the Recommendations of the Financial Action Task Force, FATF, with respect to measures to counter proliferation financing, to make consequential amendments to the Economic Sanctions Act and for related matters.
My apologies, Laura. Yes, the Honourable Leader of Government Business.
Thank you, Mr. President. Mr. President, I beg to move that the Senate do now adjourn to a date to be fixed.
Honourable Senators, the question is that the Senate do now adjourn to a date to be fixed. All in favour say aye. Any against? The ayes have it. The Senate now stands adjourned to a date to be fixed.